Hello, good evening, and welcome to Unacademy, a one-stop destination for the English medium civil services aspirants. Welcome to the BEAR Act, and today is Lecture 3 of the BEAR Act. If somehow we are unable to complete the BEAR Act today, I will schedule another class to comprehensively cover this text, the BEAR Act of the Constitution of India, comprehensively for the prelims examination. And if this series has been aiding your civil services preparation, do let me know in the comment section, and do not forget to press the like button and subscribe to our channel if you haven't yet. And before we start, a customary announcement. If you wish to enroll with us and prepare with us in English medium for your civil services examination, and should you wish to subscribe to our UPSC course, then right now you can avail a 60% off on our courses, and with that you can also get a free extension of up to 12 months. Now, we have one or the other offer running almost all the time, and sometimes you may be wondering, what is this offer all about? And I'm not aware of it. What you can do, you can go to our website or our app and check the various courses. And should you wish to subscribe to our courses, use this code IS English, and without knowing anything about the offer or the discount, you can automatically unlock the lowest discount on this subscription fee. Let's get started, and let's look at a prelims question which was asked in 2024, and let me know if you're able to answer this question. The powers of the municipalities are given in Part 9A of the Constitution. Emergency provisions are given in Part 18 of the Constitution. Provisions related to the amendment of the Constitution are given under Part 20 of the Constitution. So does that mean you have to remember and memorize all the parts of the Constitution? Yes. And for that, let's understand. There are some things which are conceptual, and there are some things for which you may need mnemonics so as to remember and memorize these parts. Our Constitution, as you would know, it starts with the preamble. And the initial parts you should automatically memorize. That Part 1 deals with the names and the details of the states and union territories, the union and its territory. Part 2 deals with citizenship. Part 3 deals with fundamental rights. Part 4 deals with directive principles of the state policy. Part 4, capital A, which was originally not part of the Constitution, but it was added to the Constitution by the 42nd Constitutional Amendment Act 1976. Clear? Now pause here. There are 25 schedules in the Constitution, but I've told you in lecture number 1 that numbering is till 22, and today you will realize why. So Part 1 is Union and its territory. Part 2, citizenship, fundamental rights, directive principles, fundamental duties. Then do we have a federal polity? Yes. In the federal polity, what do we have? We have union, then we have states, then we have a local government in the form of Panchayati Raj institutions, in the form of municipalities, in the form of cooperative societies. Then we have special provisions for some states, in the form of special areas, backward areas, or tribal areas, scheduled areas as we call them. This is how you will have to remember. Which means after fundamental duties, there is union, but which comes under Part 5 of the Constitution. Because Part 4A is fundamental duties. Then Part 5 is union. Part 6 would be states. Part 7 was originally part of the Constitution, but it was omitted, deleted through 7th Constitutional Amendment Act 1956. What happened because of the 7th Constitutional Amendment Act 1956? The states were reorganized in India. Although prior to that we had Part A, Part B, Part C, Part D territory. Part A territories would be the big provinces, for example, Bombay, for example, Madras. Part B would be the princely states. Part C would be those areas which were during the British time under the Chief Commissioner. And Part D would have only one territory called Andaman and Nicobar Islands. But when the states were reorganized, according to the States Reorganization Act 1956, Part A, B, C, D differentiation was done away with. And then because of that, we had 14 states and 6 union territories were created in 1956. And it is because of this constitutional amendment that the states in Part B of the first schedule, this Part 7, was deleted from the Constitution. So now we have union, then we have states. Then we have a third tier in the form of union territories. Then we have panchayats, municipalities, and cooperative societies. Panchayats, you would know, this part was added because of the 73rd Constitutional Amendment Act, 1993 or 1992. Part 4, capital A, 74th Constitutional Amendment Act, 1992-93. Then Part 9B was added, the cooperative societies, by the 97th Constitutional Amendment Act, 2011. So you don't have to remember these parts just by memorizing it without applying logic. Because Part 1 deals with union and its territory, Part 2 citizenship, Part 3 fundamental rights, Part 4 directive principles, Part 4 capital A fundamental duties, then union, states, union territories. Clear? But you should also note that Part 7 was omitted by the 7th Constitutional Amendment Act. Part 7 and the 7th Constitutional Amendment. After that, we will have panchayats, municipalities, and cooperative societies. All of them have the same number, Part 9. So Part 9 is panchayats, Part 9 capital A municipalities, Part 9 capital B cooperative societies. So when we have union, we have states, we have union territories, then we have a third tier in the form of panchayats, municipalities, then cooperative societies. Then what is left? There are scheduled and tribal areas. Scheduled areas and tribal areas under Schedule 5 and Schedule 6 of the Constitution. That comes under Part 10. So when center is done, union is done, states are done, union territories are done, local government is done, then tribal areas, scheduled areas are done, then ideally what should be the second part, the next part? The relationship between the center and the states. The relations between center and the state comes under Part 11 of the Constitution. After this, I will tell you an acronym which you can use to memorize this. You may be preparing for the civil services examination, but you may also be preparing for your state public civil services. PCS, TSO, EMAS. PCS, P stands for finance, property, contracts and suits. You can sue the government of India. You can sue the state. So P, you have to keep in mind, deals with property. Then C deals with trade, commerce and intercourse within the territory of India. P, property. C, trade, commerce, intercourse within the territory of India. S, services under the union and the states. For example, central civil services, state civil services, all India services. Then TSO. T stands for tribunals. But here you have to keep in mind that tribunals were not originally part of the Constitution. Tribunals got added because of what constitutional amendment? 42nd Constitutional Amendment Act, 1976. E deals with elections. S deals with special provisions related to certain classes, not states, classes, and which I'm going to tell you what are these special classes. O deals with the official language, the controversial one, which is in the news these days. EMAS deals with, E stands for emergency provisions. M stands for the miscellaneous provisions. A talks about amendment to the Constitution. S talks about special provisions for some states. For example, Article 371. It also talks about temporary provisions. For example, Article 370. It was under Part 21 of the Constitution. And the last part is 22, which talks about the short title, which talks about the commencement of the Constitution. Because I have told you that although the Constitution got enacted on the 26th of January 1950, but there were some provisions of the Constitution which came into force on 26th November 1949 itself. And which are those articles? Which are those provisions? That is something that we will discuss under Part 22 of the Constitution. So total parts are 25, but these are numbered till 22. Seventh part was omitted by the 7th Constitutional Amendment Act. Part 4 capital A deals with fundamental duties, added by the 42nd Amendment. Tribunals also got added by the 42nd Constitutional Amendment Act. Similarly, we have Part 9, which deals with Panchayats, Part 9 capital A, which deals with municipalities, Part 9 capital B, which deals with cooperative societies. So in total, 25 parts, but numbered till 22. And you can use this acronym PCS, TISO, EMAS to memorize other parts, because the first parts should be remembered and memorized through logic. Clear? Then although we have 25 parts in the Constitution, but how many schedules do we have? Initially, at the time of the commencement of the Constitution, we had 8 schedules, but then 4 more schedules got added. That means in total today we have 12 schedules of the Constitution. 12 schedules of the Constitution. For example, Schedule 1. It talks about the names and the details of states and union territories, because that's what Article 1 says. First, you need to keep in mind, what is a schedule? Schedule, we say, it is an explanatory memorandum of an article. If an article needs more explanation, we add the explanation at the end in the form of a schedule. Why, sir? Because we say it is a cosmetic measure. Otherwise, the article would become bulky. Maybe the members of the Constituent Assembly, they were fitness freaks. They would say the lean is in. As much as possible, the article should be leaner. So if you have to add an explanation to an article, that explanation has to be added in the form of a schedule at the end of the Constitution. But schedules are part of the Constitution. How many schedules do we have? 12. Schedule 1 talks about in match the following types questions. This can be important. Or something like the question was asked in Prelims 2024. Part X deals with what? Part Y deals with what? Part Z deals with what? Similarly, maybe in Prelims 2025, you may be asked about the schedules. For example, Article 1, when it says India, that is Bharat, shall be a union of states. And then Article 1, Clause B, it talks about the names of the states and union territories shall be specified where? In the first schedule of the Constitution. So first schedule does not talk about only the names of the states and union territories. It also talks about the details. Details in the sense, what is the territory of that union territory? What is the territory of that particular state? Schedule 2 talks about the salaries and emoluments of president and other constitutional functionaries. Just keep in mind. Schedule 3 talks about oath or affirmation. Oath, you would know, is for a believer. Somebody who believes in a religion, prescribes to a religion, believes in God. I swear in the name of God that I will bear true faith and allegiance to the Constitution of India, and then I will faithfully discharge the duties of the office about which I am about to enter. Affirmation is for a non-believer, somebody who doesn't believe in God. And what is the oath that he or she will take? I solemnly affirm that I will bear true faith and allegiance to the Constitution as per the law established, so on and so forth. But you also need to keep in mind that the oath for the President of India, the oath for the Vice President of India, the oath for the Governor of a state, that is not mentioned under Schedule 3 of the Constitution, that is mentioned under the text of the Constitution itself. But the oath for a candidate to contest election, because when you have to contest election, you have to file your nomination papers, and at that time you also have to subscribe to an oath before the returning officer. That oath is mentioned under Schedule 3. Oath for a minister, oath for, let's say, the CAG, oath for the judges of the Supreme Court and High Court. All these are mentioned under Schedule 3 of the Constitution. Schedule 4, it talks about allocation of seats in the Council of States. Allocation of seats in what we call the Rajya Sabha. For example, there will be 31 MPs in Rajya Sabha from UP. Where is it mentioned? Schedule 4. There will be 11 members in Rajya Sabha from Andhra Pradesh, mentioned in Schedule 4. There will be 7 from Telangana. There will be 19 from Tamil Nadu. All these are mentioned where? In Schedule 4 of the Constitution. Then Schedule 5 and Schedule 6. Schedule 5 talks about administration of the scheduled areas. Which are these scheduled areas? Listen to me carefully. This is a Schedule 5 area. This is a Schedule 6 area. Schedule 5 talks about the administration of tribals, and for them we have created something called the scheduled areas, where in states other than Assam, Meghalaya, Mizoram, and Tripura. For example, there are 11 states in India where we have a scheduled area, where we have scheduled areas. Constitution says the President of India can establish a scheduled area in a state where there is a significant amount of the tribal population. And then the governor of that state has the responsibility to administer that scheduled area. And how will the governor administer that scheduled area? By establishing a tribes advisory council. This tribes advisory council may have, let's say, 20 members. 3/4 of them shall be the tribal MLAs, and remaining are nominated by the governor. But sir, why are these 4 states excluded? These 4 states are excluded because these 4 states are exclusively covered under Schedule 6 of the Constitution. So Schedule 6 talks about the administration of the tribal areas in states such as Assam, Meghalaya, Mizoram, and Tripura. Apart from these 4 states, in any state, whenever we see a significant tribal population, the president may establish a scheduled area, may increase the area of that scheduled area, decrease the area, alter the boundaries of that area, and then the governor has the responsibility of administering that scheduled area. And how will governor administer that scheduled area? By establishing a tribes advisory council. Who are the members of this tribes advisory council? 20 members, 3/4 of them would be the tribal MLAs. Because if this is a state where there is a scheduled area, which means tribal population is present, which means in that state there will be seats reserved in Legislative Assembly for tribals. Those tribal MLAs will be part of the Tribes Advisory Council, and the remaining will be nominated by the governor. But as the name suggests, this is a Tribes Advisory Council. That means whatever recommendation is given by this Tribes Advisory Council to the governor is not binding on the governor. But sir, then what is the purpose of Schedule 5? Schedule 5, please keep one thing in mind and use it forever. Schedule 5 is for the protection of the economic interests of tribals. There are tribals in Chhattisgarh, for example, in Jharkhand, for example, in Tamil Nadu, for example. These tribals more or less are similar to the non-tribal population. But even then, we have to protect their economic interests. Economic interests, for example, the sale of tribal land to non-tribals, regulating or controlling money lending, because you may have read modern history and you would have realized that lots and lots of uprisings took place during the British colonial period, even before the revolt of 1857. And that was primarily because the British entered these tribal areas through money lenders. Money lenders would provide money to these tribals, and once they were unable to repay those loans, then their land would be confiscated. This is where the British also introduced a policy where the British imposed restrictions on shifting agriculture. For example, Joom, Poda, for the tribals, because these tribals, they believe that this land belongs to them. It is a communally owned land. This land belongs to the entire community. There is no private property. And we can sow our crops on this piece of land, and you would know over a period of time the fertility of the soil would reduce, would decline. Then you will shift to another piece of land. But this is where restrictions, limitations were imposed by the British. And that's how we saw hundreds of peasant movements, tribal movements during the colonial period. And then the constitution makers thought that for these tribals, we have to protect their economic interests. That is why if there is a law passed by the state legislature, if there is a law passed by the parliament related to land acquisition, the governor will have the power to decide whether such a law will apply to the scheduled area or not, because our intention is to protect the economic interests of these tribals. That's it. That's something that you have to keep in mind. Schedule 5 is for the protection of the economic interests. But then there are tribals in Assam, Meghalaya, Mizoram, and Tripura. And we have to protect, according to the constitution, not only their economic interests, but their social customs as well. Their religious matters as well. Their family matters as well. Their divorce matters as well. That is why constitution envisages that for these areas, we have to give them autonomy. And for these areas, we will establish autonomous districts. What is that autonomous district? For example, entire Assam is not a tribal area. Entire Meghalaya or Mizoram or Tripura, these are not tribal areas. There are 3 districts in Assam, 3 districts in Meghalaya, 3 districts in Mizoram, 1 district in Tripura, which comes under Schedule 6 area. For example, in Meghalaya, we have 3 districts, 1 for Garos, 1 for Khasis, 1 for Jaintias. And remember, these are also 3 hills that are found in Meghalaya. So whenever Garos are inhabiting a particular district, listen to me carefully, Constitution envisages that establish an autonomous district where Garos can govern themselves. Which means for these autonomous districts, there will be district councils. And these district councils, my dear, these are democratic institutions. Democratic institutions in the sense, if 30 members is the composition of this district council, 26 would be directly elected by the Garos. Remaining 4 will be nominated by the governor. And this district council, they will have the power to make laws for Garos, for that district. They have the financial powers as well to impose certain taxes or to collect tolls. They have the power to regulate education. They have the power to regulate their marriage and divorce. Because the idea is that in Schedule 6 areas, we have to protect not only the economic interest of the tribals, but also their social customs, their religious customs. That is Schedule 5 and Schedule 6 area. So Schedule 5 talks about the administration of scheduled areas in states other than Assam, Meghalaya, Mizoram and Tripura. But for Schedule 6, these are exclusively for these 4 states, Assam, Meghalaya, Mizoram and Tripura. And the idea is to protect them by creating autonomous districts. Schedule 6 also talks about, for example, this is a district where more than one tribe is inhabiting, let's say tribe X, tribe Y. Then instead of creating autonomous districts, you create autonomous regions. And then these autonomous regions will have, instead of a district council, it will have a regional council. These facts are very important, can be relevant for your examination. Then Schedule 7, it talks about the distribution of legislative subjects. For example, into union list, state list and concurrent list. For example, matters related to defense, external affairs, communication, banking, insurance, citizenship, extradition. On all these matters, who has the power to make laws? Only the parliament, and those matters are under union list. Then we have matters under the state list. For example, agriculture, gambling, police, law and order, land. All these are the matters which are under the domain of, under the jurisdiction of the respective state legislative assemblies. But then there are those matters which are under concurrent list, where both parliament as well as state legislature has the power to enact laws. For example, education, which previously was under state list, but during the emergency, because of the 42nd Constitutional Amendment Act 1976, education was shifted from the state list to the concurrent list. Similarly, matters related to marriage, criminal procedure, civil procedure, these are the matters under which both parliament as well as the state legislature has the power to make laws. But sir, I have a question. What if the law passed by the parliament and the laws passed by the state legislature on a matter mentioned in the concurrent list, they are not compatible with each other? They are not in agreement with each other. Park your thoughts, park your doubts. I'm going to discuss this in great detail when we will discuss center-state relations. But here we are just looking at what are schedules. So Schedule 7 talks about union list, state list, concurrent list. Schedule 8 talks about languages. Initially, there were how many languages? 14 languages. But now, how many languages do we have? 22 languages. Can anybody tell me, is English part of 8th schedule of the Constitution? No, despite the fact that it is one of the official language, but Schedule 8 talks about Indian languages and English is not part of it. Does it also include Rajasthani? Is Rajasthani part of the 8th schedule of the Constitution? No. Sir, why are you talking about English and Rajasthani? Because recently there was a controversy surrounding the Sahitya Akademi Award, where Bengali was, according to Bengali writers, discriminated against. But according to Sahitya Akademi, under which languages will you be conferred this award? All the languages which are recognized by Sahitya Akademi. And Sahitya Akademi recognizes these 22 languages. Apart from that, it also recognizes English as well as Rajasthani, despite the fact that these are not under the official languages mentioned under 8th schedule of the Constitution. Clear? Then Schedule 9, it talks about those laws which are placed in 9th schedule. There is no judicial review. And we have discussed that when we discussed Bear Act number 1, how because of the first Constitutional Amendment Act 1951, this ninth schedule got added. And I've also told you that all laws which are placed in ninth schedule till 24th April 1973, till the Keshavananda Bharti judgment, there is no judicial review. But the laws passed and inserted into the ninth schedule after the Keshavananda Bharti judgment, there will be a judicial review. There can be a judicial review. Then there is 10th schedule, which was added by the 52nd Constitutional Amendment Act 1985. And it talks about what? It talks about the anti-defection law. And what is this anti-defection law? Listen to me carefully. There are 4 sets of members who can be there in the legislature. For example, we say you are a member of a house. And as a member of a house, you belong to a political party. Which is this house? This house, my dear, can be Lok Sabha, Rajya Sabha, Legislative Assembly, Legislative Council. So anti-defection law applies to all these. Does it apply to panchayats and municipalities? No. Can states have their own anti-defection law for municipalities and panchayats? Yes. But is 10th schedule applicable to municipalities and panchayati raj institutions? No. 10th schedule says, if you are a member of a house and if you belong to a political party and then you voluntarily resign, if you voluntarily resign, you are disqualified. Now, the courts have said voluntary resignation does not mean that you have to formally submit a resignation letter and that would be construed to be your resignation. Voluntary resignation would also mean that even in absence of a formal resignation letter, if we can assume that your conduct outside the house is such that we can assume that you have voluntarily resigned from your party. For example, without submitting resignation, you are carrying out anti-party activities. You are not attending the meetings called by the party. You are attending the meetings and the rallies of the opposition political party. It can be construed that although you have not submitted the formal resignation letter, but your conduct outside the house is such that we can assume that you have voluntarily given up your membership of a political party, you can be disqualified. So a member of a house belonging to a political party is disqualified if you voluntarily resign. Second, if you violate the whip. And whip, which whip are we talking about? We are talking about 3-line whip. First line whip, 1-line whip or 2-line whip is not coercive in nature. That means even if a member of a house belonging to a political party violates a 1-line whip or a 2-line whip, you will not be disqualified. But if you violate a 3-line whip, then you may be disqualified, provided the political party does not condone your violation within 15 days. Sir, what does that mean? A no confidence motion was introduced in Lok Sabha against the Prime Minister, Mr. Modi. Now a whip has been issued to all the MPs belonging to the Congress party that you have to vote in favor of this no confidence motion. Rahul Gandhi, carrying this bare act with him, decides to vote against this no confidence motion. He could not understand whether to vote or against. He thought that I have to oppose the Prime Minister, I will have to oppose this no confidence motion as well. So although the whip was that you have to vote in favor of this no confidence motion, he votes against. Will the Speaker Om Birla disqualify Rahul Gandhi? Ideally, yes. But if the Congress party says within 15 days in a written format that we condone the violation of the three-line whip by Shri Rahul Gandhi, then Speaker cannot disqualify Rahul Gandhi. So even if you are violating a three-line whip, but you have got 15 days to get it condoned by your political party. If that is done, you will not be disqualified. Otherwise, you will be disqualified. What if you are a member of a house, but you do not belong to any political party? For example, you are an independent member. Can this independent member of a house join a political party after his or her election? No. If you join, you are disqualified. Now, another member can be a nominated member. Nominated member is provided 6 months to decide. If after your nomination to Rajya Sabha, because there are no nominated members in Lok Sabha, there are no nominated members in the Legislative Assembly, there are nominated members to the Legislative Council. So if you are nominated by the President to the Rajya Sabha, you're nominated by the Governor to the Legislative Council, you have got 6 months to decide which political party to join. But if you join a political party 6 months after your nomination, then you are disqualified under the provisions of the 10th schedule of the Constitution, which is what we call the anti-defection law. But the question is, who will disqualify you? This disqualification is entrusted to the Speaker of Lok Sabha Legislative Assembly, the Chairman of the Rajya Sabha or the Legislative Council. Constitution says that the decision of the Speaker and Chairman shall be final. But when this matter reached the court, in a famous case known as Kyohoto Holoho versus Zachilhu, 1992, Supreme Court said, yes, the decision will be taken by the Speaker, but it is not final because there can be judicial review. Because judicial review is what? It's part of the basic structure of the Constitution. When was the first time that Supreme Court said judicial review is part of the basic structure? This was told by the court in Minerva Mills case, 1980. But is there a time period within which the Speaker and the Chairman will have to act on the disqualification petitions? There is no time period. Now, I will ask you another question. What if tomorrow we realize that the Speaker or the Chairman who has to act on disqualification petitions, the Speaker himself or herself is subject to disqualification under the provisions of the anti-defection law? In that case, who will disqualify the Speaker? In that case, something or somebody who is decided by the House. The House may choose somebody from amongst themselves, and this person will decide whether the Speaker should be disqualified under anti-defection law or not. This is the provision related to the 10th schedule of the Constitution added by the 52nd Constitutional Amendment Act, 1985. And then the last two schedules which got added, Schedule 11 because of the 73rd Amendment, Schedule 12 because of the 74th Amendment. And what is this 11th and 12th schedule? Now listen to me carefully. Panchayati Raj institutions and urban local bodies. The first Panchayati Raj institution was established in the Nagaur district in Rajasthan in 1959. Why? Because there was a committee headed by Balwant Rai Ji Mehta. Balwant Rai Ji Mehta committee was not set up on Panchayati Raj institutions. No. Balwant Rai Ji Mehta committee was set up to look into, to review the community development programs, the National Extension Service. And then Balwant Rai Ji Mehta recommended that we should go for democratic decentralization. That means we should create Panchayati Raj institutions. But these institutions should be democratic in the sense that people should elect representatives to this third tier. And all developmental work should be entrusted to this Panchayati Raj. But then this union government realized that what Balwant Rai Ji Mehta is basically recommending is under the domain of the states. Why? Because the 7th schedule of the constitution that we discussed, where the powers are distributed between the center and the states, local government comes under state list. There is union government, there is state government, and then there can be local government. Local government is under state list. So if at all somebody has to enact a law on local government, that can be done only by the state legislative assemblies, not by the parliament, not by the union in any case. So the union government said, Balwant Rai Ji Mehta, it's a good suggestion, but we are helpless in the situation because local government comes under the domain of the states. And this is where in 1958, a meeting of National Development Council took place. And you would know that National Development Council consisted of, because now it's a defunct body, it's no longer in existence. It used to consist of the Prime Minister, all the chief ministers. So it was some form of a federal body. And in that meeting of the NDC, it was decided, okay, we will implement the recommendations of the Balwant Rai Ji Mehta. But one rigid pattern was not insisted upon, which means there were some states which created a three-tier structure. Some states created a two-tier structure. For example, Tamil Nadu. Some states, for example, West Bengal, created a four-tier structure. So there was no common uniformity or a uniform structure in this local government. But long story short, it was first established in Rajasthan, then in Andhra, and then subsequently in various other states. But when these Panchayati Raj institutions were established, we were primarily wanting to implement directive principles of the state policy. Because Article 40 talks about that it shall be the duty of the state, that what you have to do, you have to organize panchayats and empower them with powers so as to enable them to function as units of rural, local self-government. Self-government, which means self-government is only possible if there is autonomy over 3 Fs. 3 Fs in the form of functions, funds, and functionaries. But be that as it may, Panchayati Raj institutions were established, then abolished. And re-election would not take place. These Panchayati Raj institutions were created only for namesake, but they were not empowered with funds, with functions, with functionaries. Ultimately, it was recommended to Rajiv Gandhi, who was the Prime Minister, by the LM Singhvi committee that we should give constitutional status to Panchayati Raj institutions. Constitutional status in the form that mention it in the Constitution. Constitution is the supreme law of land, which means by then the states would have no power whatsoever. These are constitutional entities, have to be created, have to be empowered, have to be reconstituted if there is premature dissolution. But states objected. How dare you make a law on an item which is there in the state list, because local government comes under the domain of the states. This is where this bill was defeated in the Rajya Sabha, because Rajya Sabha represents the interest of the states. And then various other committees were set up. Mr. VP Singh also tried to do something. He also conducted a meeting, organized a meeting of the NDC. Couldn't happen. His government fell. Then ultimately this matter came up when Shri P.V. Narasimha Rao was the Prime Minister. Again, constitutional status was given to panchayats and municipalities. But now listen to me carefully. Very important point. These Panchayati Raj institutions and urban local bodies, they are not created by the parliament. In every state, they are created by the laws passed by the state legislature. Which means in Karnataka, we will have urban local bodies and panchayats based on the laws enacted by the Karnataka legislature. Similarly in UP, similarly in Chhattisgarh, similarly in Punjab, similarly in Tamil Nadu. But then the constitution says, whenever state legislature will enact a law, it has to necessarily incorporate in those laws those compulsory provisions which are mentioned in the 73rd and 74th Amendment. And if you can, maybe also incorporate voluntary provisions. These provisions should be incorporated, but it is up to you. You decide whether you want to incorporate these provisions or not. But compulsory provisions you have to include. Why? Because now the states have accepted it. Through negotiation, okay, we will implement these provisions. And what are these provisions? Number one, Gram Sabha. What is Gram Sabha? In a particular village, all the registered voters of that village, they are part of the Gram Sabha. Gram Sabha has to be established. It is a compulsory provision. But what powers will be entrusted to this Gram Sabha? That is to be decided by the law passed by the state legislature. Gram Sabha, which is the body of all the registered voters of that village, it has to be constituted. But what powers will be entrusted to this Gram Sabha? That the state legislature will decide by enacting its law. Then you have to create a three-tier structure. It's a compulsory provision. Compulsory provision in the form of there has to be Gram Panchayat. There has to be Panchayat Samiti. There has to be Zilla Parishad. You have to constitute it. But if you are a state where the population does not exceed 20 lakhs, you don't have to create this intermediate structure. You can only have a two-tier structure. So apart from Gram Sabha, you have to ensure that there is a three-tier structure. Gram Panchayat, Panchayat Samiti, Zilla Parishad. Gram Panchayat for every village, then Panchayat Samiti for a group of villages at the block level, then Zilla Parishad at the district level. But if you are a state where the population is not more than 20 lakhs, then you don't have to create Panchayat at the block level. You can have Panchayats only at the district level and the village level. And in all these three stages, there has to be direct election. So people will elect their representatives directly to these three-tier structure. It's a compulsory provision. What is also compulsory provision is that there should be reservation for SC and ST. And what is the percentage of that reservation? In proportion to their population. There has to be reservation for women. What is the percentage of that reservation? Listen to me carefully. Not less than 1/3. Not less than 1/3 of the members to these panchayats should be women. Not less than 1/3. Can it be more than 1/3? Yes. That is why there have been states where reservation for women in Panchayati Raj institutions is also 50%. It can't be less than 1/3, but it can be more than that as well. Election has to take place, and the term of this Panchayati Raj institution has to be 5 years. What should be the qualification? What should be the disqualification for those who want to contest elections? That will be determined by the law passed by the state legislature. But no one shall be disqualified only on the grounds that you are 21 years of age. That means the minimum age requirement for somebody to contest election to panchayats and municipalities is 21 years. For Lok Sabha, it is 25. For Legislative Assembly, it is 25. For Legislative Council, it is 30. For Rajya Sabha, it is 30. But for panchayats and municipalities, it is 21 years. But now listen to me carefully. Additional qualifications and disqualifications can be prescribed by the state law. That is why there have been various states which have recommended educational qualification in order to contest elections. Some states have recommended that you should have a functional toilet. If you don't have a functional toilet, you are disqualified from contesting elections. So you need to keep in mind what are the compulsory provisions, what are the voluntary provisions. So if there is reservation for SC, ST and women, it is compulsory. But can there be reservation for other backward classes? Yes. But that's a voluntary provision. If the state legislature wants, it can enact a law and provide reservation for OBCs as well. But it is not a compulsory provision. Compulsory provision is that there has to be a state election commission. Elections to panchayats and municipalities shall be organized by a single member state election commission. And the state election commissioner shall be appointed by the governor and shall be removed just like the judge of the judge of the High Court. Now listen to me carefully. 73rd and 74th Amendment not only talks about State Election Commission, it also talks about State Finance Commission. Just like we have a Union Finance Commission constituted by the President after every 5 years, we have the State Finance Commission constituted by the Governor every 5 years. And what will the State Finance Commission say? All the taxes, all the revenue which is generated by the state, what is the proportion of those taxes that can be shared with the local government institutions, with the local government, with the panchayats and municipalities? That is decided by the State Finance Commission. But the State Election Commission is headed by the State Election Commissioner, who is appointed by the governor and can be removed just like the judge of the High Court is removed. And how is the judge of the High Court removed? Removed by the President based on the resolution passed by both houses of the Parliament by special majority. But sir, I have a question. What? Sir, in case of Andhra, how did the government of Andhra initially decide to remove the State Election Commissioner? Although it was later on overturned by the courts, but how did they decide it in the first place? Listen to me carefully. Panchayati Raj institutions and municipalities will have to be established in every state based on the law passed by the respective state legislatures. But when the state legislature is enacting that law, it has to necessarily include the compulsory provisions. It may also include the voluntary provisions. Compulsory provision is that the State Election Commissioner will have to be appointed by the governor, but can be removed just like the judge of the Supreme High Court is removed. But other service conditions of the State Election Commissioner will have to be decided by the law passed by the state legislature. Other service conditions, for example, what should be your tenure? Will it be 2 years, 3 years, 5 years or 10 years? What should be your qualification? Constitution only says that you should be appointed by the governor and you can be removed just like the judge of the High Court is removed. But who are you going to be? Qualification, terms and conditions, tenure, everything has to be decided by the law passed by the state legislature. So there was one state election commissioner who decided not to organize panchayat elections, local body elections in Andhra Pradesh, saying there is COVID. The then government headed by Mr. Jagan Mohan Reddy insisted no, that you have to organize elections. But he did not. Then an ordinance was promulgated. And this ordinance says that from now onwards, the term of the state election commissioner, which used to be 5 years, this term has been reduced to 3 years. Because who can decide your service conditions? The law passed by the state legislature. And we have now decided that your term is not for 5 years, it is for 3 years. And this state election commissioner had already completed 3-year tenure. Which means, since I could not remove you directly, because you can be removed by the president on the basis of the resolution passed by the parliament, I will remove you indirectly by changing your service conditions, by reducing your term from 5 to 3 years. This, the court said, can be the classic example of a colorable legislation. Because what you can't do directly, you cannot do indirectly as well. You can't directly remove the state election commissioner. And you are trying to indirectly remove the state election commissioner by reducing his term from 5 to 3 years. This is not acceptable. This ordinance is unconstitutional. Okay? Great. But how do we empower these Panchayati Raj institutions? Constitution says state legislature may devolve these functions, and there are 29 functions mentioned under the 11th schedule of the Constitution, which can be devolved to Panchayati Raj institutions. Agriculture, land improvement, rural electrification, drinking water, sanitation, education. In fact, all day-to-day activities should ideally be entrusted to Panchayati Raj institutions. That is why critics say that instead it should have been the state legislature it should have been mandatory on part of the state legislature to devolve these 29 subjects to Panchayati Raj institutions. But Constitution says the state legislature may. Why? Because otherwise states would not have accepted giving constitutional status to panchayats. And we have discussed various reports where a large number of states, they have not devolved all these subjects. Similarly, what are the subjects that should be devolved to municipalities, to urban local bodies? Those are 18 items mentioned under 12th schedule of the Constitution. So 11th and 12th schedule. 11th schedule deals with panchayats. 12th schedule deals with municipalities, the urban local bodies. And it talks about the subjects, the functions, which may be devolved to local bodies by the state legislature. But now listen to me carefully. I'll use a different color to highlight this. When did the 73rd Amendment enter into force? What if I tell you, you have to tell me whether this statement is correct or incorrect. Both the 73rd and 74th Amendment entered into force in one go together. Is that statement correct or incorrect? Both the 73rd and 74th Amendment entered into force together. 11th schedule, it got added in 1992, but with effect from 24th of April 1993. 12th schedule, which got added by the 74th Amendment 1992, but it entered into force with effect from 1st of June 1993. So they did not enter into force in single go together. That's something that you have to keep in mind. Clear? Part 10, we have discussed deals with scheduled and tribal areas. Provisions of fifth schedule will apply to states other than Assam, Meghalaya, Mizoram, and Tripura. Schedule 6 deals with exclusively the states of Assam, Meghalaya, Mizoram, and Tripura. Clear? Now let's discuss the most important part, relations between the union and the states. Who has the power to make a law for the entire country or any part of the country? Parliament. Which means the law passed by the Parliament will be applicable throughout the territory of India. Who has the power to make a law, or should we say the law passed by the state legislature will be applicable within the state? For example, can the Uniform Civil Code implemented by the state of Uttarakhand be implemented in the entire country, the same law? No, that Uttarakhand law will be applicable within the state of Uttarakhand. Clear? But Parliament has the power to enact an extra territorial legislation. This power is not applicable, is not available to the state legislature. State legislature can enact a law which will be valid within the state, but Parliament has the power to enact a law which can have extraterritorial jurisdiction as well. Which means the laws passed by the Parliament are applicable to Indian citizens and their property outside India as well. That's something that you have to keep in mind. Let's look at something else. I've told you that there is union list, state list, concurrent list. There are items in union list, there are items in state list, there are items in concurrent list. What if there is an item which is not mentioned in any of these three lists? It's a residue left over. On this residuary subject, who has the power to make a law? This power is given to the Parliament. And this is where we deviate from the US federal model, because residuary powers are vested in states in case of United States of America. But in case of India, these residuary powers are vested with the Parliament, with the Union, not with the states. Article 249, for example. Even if there is an item in the state list on which state legislature has the power to make a law, for example, law and order. Who has the power to enact a law on law and order? The state legislature. But on this subject, Parliament is empowered to make a law, or can be empowered to make a law if it is in national interest. But only if Rajya Sabha passes a resolution. Resolution which should be passed by not less than 2/3 of the members present and voting. Although there is a clear-cut distribution of powers between the union list, state list, and concurrent list. But on an item mentioned in the state list, for example, law and order, can Parliament enact a law on state list? Yes. When? If Rajya Sabha, which is the representation of the states, which represents the interest of the states and the Parliament, if Rajya Sabha passes a resolution by not less than 2/3 of the members present and voting, saying that dear Parliament, it is in national interest that you make a law on state list, then Parliament can make a law on state list under Article 249. But what you also need to understand is what is the validity of this law? This law would be valid for 1 year. Can it be extended? It can be extended, but only if Rajya Sabha again approves it, extension for another 1 year. Can it be extended further? Yes. For that, again, the Rajya Sabha has to pass a resolution by not less than 2/3 of the members present and voting. This is Article 249. Power of the Parliament to legislate with respect to a matter in the state list, but keep in mind, it has to be in national interest. Then Article 250. There is national emergency in place. And during national emergency, Parliament assumes concurrent power of legislation. With respect to states. Listen to me carefully. There is union list. Who has the power to make a law on union list? Parliament. There is state list. Who has the power to enact a law on any matter mentioned in the state list? State legislature. Then there is concurrent list. Who has the power to make a law when it comes to a matter enumerated in concurrent list? Both Parliament as well as state legislature. But when the proclamation of emergency, and whenever Constitution mentions emergency, you have to keep in mind that we are talking about Article 352, which is the national emergency. Whenever there is an emergency in place, proclamation of emergency under Article 352, we say Parliament assumes concurrent power of legislation, which means you can say that there is no state list during emergency. Every item in the state list you can assume is part of the concurrent list, which means both Parliament as well as state legislature, you have the power to make a law on agriculture, on land, on law and order, on gambling, on police during national emergency. And what is the validity of this law? This law will continue till proclamation of national emergency continues. And if the proclamation has been revoked today, if national emergency has been revoked today, this law will further continue for a maximum period of 6 months. After that, this law will lapse. Which means, what is the validity of the law passed under Article 249? 1 year, but can be extended again. What is the validity of the law passed under Article 250? Till the time national emergency is in place, this parliamentary law will prevail. And if national emergency is revoked today, this law shall continue for a maximum period of 6 months. After that, it will disappear. It will lapse. Now, listen to me carefully. Assume that Parliament has enacted a law on state list using Article 249. Let's say on police, for which there was already a law passed by the state legislature previously. Or Parliament has enacted a law under Article 250 when national emergency is in place on, let's say, law and order. And on law and order, state legislature also has the power to enact a law. What if the law passed by the state legislature is not in agreement with the law passed by the Parliament under Article 249 and 250? Which law will prevail? Can you tell me which law will prevail? Parliamentary law will prevail? Or is it that if this law passed by the state legislature has been reserved for the consideration of the president, and the president has approved that state law, it is the state law which will prevail over the parliamentary law? Is that correct or incorrect? Then state law. No, not in this case. That is why I asked this question. If Parliament has enacted a law under Article 249 or Article 250, and then there is inconsistency between the law passed by the Parliament and the laws passed by the legislatures of the state, then under any circumstance, under all circumstances, it is only the parliamentary law which will prevail. Sir, then what was that criteria? That if the state law is reserved for the consideration of the president and it gets the approval of the president, then that state law will prevail with respect to that state? That's a different matter, which I will discuss in a moment. But here, keep in mind, we are specifically talking about the parliamentary lawmaking power using Article 249 and Article 250. Clear? Article 252. Article 252 is like a surrender. And what is the surrender? If two or more states pass a resolution requesting the Parliament that dear Parliament, you make a law on state list, then Parliament becomes empowered to make a law on state list. Sir, two things. These two or more state legislatures, they are passing a resolution asking the Parliament to enact a law. Right. Will this law be applicable to other states also who have not made the request? No. If these states are saying, "Ah, bel mujhe maar," why should other states be also subjected to that thing? So this law, which is passed by the Parliament, will be applicable on only those states which have made the request. But yes, other states which have not made that request can pass this law, can pass the same law in their state legislature. And when these states are making the request, it is as if the state legislatures, they have surrendered the subject to the Parliament. Now, Parliament may or may not ever give this subject back to the state legislature. It is as if you have surrendered it forever. When two or more states, by consent and adoption of such legislation by other state, when two or more states pass a resolution asking the Parliament to enact a law on state list, Parliament becomes empowered to make a law on that state list. And then other state may adopt the same law, because that law passed by the Parliament will be applicable on only those states which make the request, not on other states. And then Article 253. Suppose the government of India has to implement an international treaty which we have signed and ratified. For example, United Nations Convention Against Corruption. For example, Convention Against Elimination of All Forms of Discrimination Against Women. Or for that matter, if tomorrow we ratify the United Nations Convention on the Status of Refugees, or the additional protocol of that of 1967, then Parliament becomes empowered to make a law even if that is under the domain of the states. That means legislation to give effect to these international agreements. Who will have the power to enact such a law? Parliament. And states cannot say that you have enacted this law in our domain, encroaching into our domain. No. Why? Because the Parliament is giving effect to an international agreement. Now comes the point. Inconsistency between laws made by the Parliament and laws made by the legislature of the states. This is where we talk about concurrent list. Now, we are not talking about laws passed by the Parliament under Article 249 and 250. We are talking about laws passed by the Parliament on an item mentioned in the concurrent list, and laws passed by the state legislature on an item mentioned in the concurrent list. Now, if there is an inconsistency here, Parliament is also empowered to make a law on concurrent list. State legislatures are also empowered to make a law on concurrent list. What if there is inconsistency? Parliamentary law will prevail. But if that state law has been reserved for the consideration of the president, and the president has given assent to that state law, then that state law will apply to that state. For example, West Bengal passed an Aparajita bill or may pass a bill amending Bharatiya Nyaya Sanhita. Because can Bharatiya Nyaya Sanhita be amended by states as well? Yes, because it is part of the criminal procedure, which is where both center as well as states have the power to make laws, because it is under the concurrent list. And such a bill has to be necessarily reserved for the consideration of the president. And if West Bengal passes a law on criminal procedure which violates the Bharatiya Nyaya Sanhita, then if that bill is reserved for the consideration of the president gives the consent, then in West Bengal, the West Bengal law will prevail, not the parliamentary law. That is Article 254. Clear? Okay. Now listen to me carefully. You can introduce a money bill in the Lok Sabha, but for that there is a requirement. And the requirement is that money bill can be introduced in Lok Sabha only on the recommendations of the president. Or there is a bill under Article 3 of the Constitution, which talks about the reorganization of states. And this bill, reorganization of states, can be introduced in either of the houses of the Indian Parliament, but with the prior approval recommendation of the President of India. But a money bill has been passed by both houses of the Parliament without President's recommendation. A bill under Article 3 has been passed by both houses of the Parliament without prior recommendation of the President. Can you tomorrow go to the court? My lord, I have a case. What is the case? Money bill was introduced in the Lok Sabha, but it did not get the prior approval of the President. Reorganization of a state bill was introduced in the Parliament, but it did not get the prior recommendation of the President. Please declare this law as unconstitutional. If this money bill or this bill under Article 3 later on got the approval of the President, got the assent of the President, got the signature of the President, then you can say that it was a matter of procedure only. That means on this ground tomorrow, you cannot challenge it in the court saying, since prior approval was not given by the President or prior approval was not given by the governor, and on this ground, this bill should be declared unconstitutional. No. Because no act of Parliament or the state legislature or of the state legislature shall be invalid only by the reason that some recommendation or previous sanction which is required by this constitution was not given. If later on assent was given by the president or the governor, then it means that my prior recommendation, my prior consultation was only a matter of procedure. And since you did not follow the procedure, now you have passed the money bill, you have given it to me for signature, I will sign it. And if I sign it, it means that you got my prior consent as well, prior approval as well. This can be a very important statement for your prelims. It's under Article 255. And we are discussing here center-state relations. Now let's look at administrative relations. For example, obligation of the states and the union. Who has the power to make a law on citizenship? This power is available with the Parliament. And Parliament has enacted a law called the Citizenship Act. Of 1955. This was last amended in 2019. called Citizenship Amendment Act 2019, where Parliament said if you are from Pakistan, Afghanistan, or Bangladesh, and if you have entered India on or before December 31, 2014, and you belong to the 6 religious minorities of these 3 Islamic countries, then you will not be deemed as a legal migrant. When you're not deemed as a legal migrant, that means you're eligible for citizenship. Can Bengal say, I will not implement this law in Bengal? Or Kerala says, I am not going to implement this? That can't happen. Because state has an obligation that you have to be in conformity. You have to treat the parliamentary law with respect. You have to comply with the law passed by the parliament. And if the center wants, center can issue directions to ensure that you comply with the law passed by the parliament. Something else. There are highways. There are waterways. Who has the power to declare a highway as a national highway or to declare a waterway as a national waterway? Obviously, this power is available with the parliament. But highway will have to pass through the state. Waterways are within the states or from one state to another. Center can issue directives to the states that you have to do 2 things. You have to construct, you have to maintain. What you have to construct, what you have to maintain? A naval base, an air base, or a military base. And if you fail to abide by these directives, then we can assume that there is breakdown of constitutional machinery in that state and president's rule can be imposed in that state. Article 356 can be imposed. Dismiss that state government. Not just related to highways or waterways or air, navy or military air bases, but also with respect to railways. Directives can be issued that you have to maintain and construct these railways. Now listen to me carefully. Can be an important point. To construct it, state may need to invest. States may need to incur expenditure. Will this expenditure be given by the center? Yes. But what if center defaults on this payment? Where do you go? You will have to go to an arbiter. And this arbitrator will have to be appointed by the Chief Justice of India. That means normally there is a dispute between center and the state. That dispute is related to jurisdiction. For example, if the center is assaulting the rights and powers of the states, that dispute can go to the Supreme Court under Article 131. But this time it's about payment. Payment in the sense, you asked us to maintain this means of communication. For example, railways, for example, waterways, for example, highways. And we have incurred an expenditure which you promised that you will give it to us. But now you are not giving, you are defaulting. Now in this case, where do we go? We go to an arbitrator. And this arbiter will have to be appointed by the Chief Justice of India. And if the state fails to abide by these directives are issued under Article 365, which we will discuss later. If the state fails to abide by these directives, it can be assumed that there is breakdown of constitutional machinery. Then after that, Article 356 can be imposed, which means the Chief Minister, the Council of Ministers are dismissed. Now listen to me carefully. All executive powers of the Union are with the President. All executive powers of the states are with the governor. There is something called distribution of power. There is something called separation of power. There is something called delegation of powers. Or there is something called devolution of powers. What is the difference? In simple terms, although there are much more different levels of intricacies involved, but in basic literal terms, distribution of power means this is the power, it is to be distributed. Some subjects are to be given to the center, some subjects are given to the states. So we have distributed these legislative subjects. For example, we have these many subjects for civil services examination. Now we have distributed polity, Sarmad sir, economics, Sham sir, geography, Mukesh sir, international relations, Chetan sir, history, Abhishek sir. We have distributed these subjects. Then there is separation of powers. Separation of powers is done into organs. Law making will be with the legislature. Implementation will be with the executive. Judiciary will be there to keep a check, or judiciary will be there to impart justice. That is separation of powers, given by Montesquieu. Although Montesquieu did not use the term separation of powers, he basically used the term distribution of powers for this. But be that as it may. Then there is devolution of powers. For example, powers are to be devolved from states to panchayats. Devolution is when a superior authority gives up some of its powers and gives it to the inferior authority. For example, states giving it to panchayats. That's devolution. Then there is delegation. Delegation in the sense, I am tired now. I think I will end this class. And another polity teacher will come and pick it up from here and continue with this bare act. But I am giving this power to that teacher. Now I am gone. But suddenly I realized as soon as I walked out of this room, no, this is my passion. I want to come back. I tell this teacher, no, you go. Now I will start teaching again. So delegation is, it can be done at any point in time. It can be revoked at any point in time. And delegation is normally through consent. The other teacher has to agree, okay, I will start teaching because I was not prepared. Suddenly you said teach bare act, a complex thing. Executive power of the union is with the president. Can the president delegate this executive power to the state? But with the consent of that state government, with the consent of that governor, yes. But can the governor delegate some of its executive powers to the president with the consent of the president? It originally was not part of the constitution. It was only talking about, our constitution originally was only talking about president with the consent of the state government could have devolved some of his executive functions to the state. But there was no such provision where the governor can delegate some of his executive powers to the central government with the consent of the state government. For that, constitution was amended 258 capital A, and this was done by the 7th Constitutional Amendment Act 1956. And this is what we call mutual delegation of powers. And with this mutual delegation of powers, center and states are coming closer to each other. I am helping you, you are helping me. This is what is leading to cooperation. And this is what we call cooperative federalism. something that we have borrowed from the Australian Constitution. You're right? But sometimes, as I told you, this delegation is through consent, mutual consent. Governor agrees, president agrees, state government agrees, central government agrees. Sometimes it is done through force. But that time it is done by parliament, not by the president. Because I told you, under Article 258, president can delegate some of her executive powers to the states, either conditionally or unconditionally, but with the consent of the state government. But what if we want to force the state government to perform that executive function? Not through mutual agreement, not through mutual respect, but with force. This time the delegation will be done by the parliament, and parliament will force the state to perform some of the executive functions. That's Article 258. Similarly, Article 261. Public acts, records, and judicial proceedings. This is what we call full faith and credit. For example, there is a couple and they decided to marry under the Special Marriage Act in Kerala. Does that mean when they travel to Delhi, there they will have to register under the Special Marriage Act again? No. Because that certificate under the Special Marriage Act would be valid throughout. In Delhi as well, in Maharashtra as well. Similarly, there is somebody who is wanted by the police in Maharashtra. I won't even take the name of the comedian. He is wanted there. But he is in Tamil Nadu. A member of a political party dials this comedian and says, "Where are you?" That I'm in Tamil Nadu, come. If there is a warrant issued in the name of this comedian in Maharashtra, and the police can come to Tamil Nadu and bring this person back to Maharashtra, Tamil Nadu police may have to also agree. Because you will respect our jurisdiction here, we will respect your jurisdiction there. This leads to seamless judicial or legal proceedings. That is what we call full faith and credit, which means final judgment or orders delivered or passed by a civil court in any part of the territory of India shall be capable of execution anywhere within the territory according to law. Which means I can present the warrant before that person in another state and bring that person back to my state. That's Article 261. Article 262 is primarily a political matter. Sir, what is that political matter? For example, interstate river water disputes. There is a dispute on River Kaveri. There is a dispute between Karnataka and Tamil Nadu. Puducherry also suffers because of this. Kerala also has one element in this. But predominantly, there's a dispute between Karnataka and Tamil Nadu. Here, is Karnataka right or Tamil Nadu wrong, or Tamil Nadu right and Karnataka wrong? We can't say. And this is primarily a political matter. And that is why Constitution has, look at the beauty of Indian Constitution. It could envisage this problem, this political matter, and says that in this political matter, exclude the jurisdiction of the Supreme Court. Don't let Supreme Court interfere. Why? Because there's a political matter, it has to be solved through political consensus. Because in these political matters, nobody is entirely right or nobody is entirely wrong. And that is why Constitution says, if Parliament wants, Parliament may enact a law. And through that law, we will adjudicate, we will decide the interstate river water dispute. And through that law, we can also say that Supreme Court stay away from it because this is a political matter. We will resolve it on our own. We will resolve it through political consensus. That's Article 262. And yes, Parliament has enacted that law in the form of Interstate River Water Disputes Act 1956, which has a lot of problems, but we don't have to discuss them here because we are discussing just the bare act. Article 62 talks about one adjudication, that how do we resolve interstate river water disputes. For that, Parliament may enact a law. But if it is not only on interstate river water dispute, it can be on any other matter as well. Let's say it can be on the partisan role played by the governor. Whether we should have a new national education policy or not. And if we want to have it, can we have a 2-language formula or a 3-language formula? This is where Constitution under Article 263 envisages a non-permanent body. Non-permanent body called Interstate Council. Constitution says, dear President, come here. If at any point of time you feel that to discuss issues, it is better that issues between center and the states can be best discussed in an interstate council, you create that interstate council. And President created that interstate council in 1990, which is headed by the Prime Minister, which contains chief ministers of all the states. But the difference is, here it is adjudication. Parliament will, by enacting a law, adjudicate, decide, resolve, rule on interstate river water disputes. But in interstate council, Parliament will only, President will consult, President will create, establish an interstate council as a consultative mechanism, where the center and the states, they will consult each other if at all there are disputes between states or between the center and the states. Disputes will not be resolved by this council, will not be adjudicated by this council, but the disputes can be discussed. We can advise, this is how we can resolve the dispute. If you want governor to be a non-partisan figure, then let's implement the Sarkaria Commission recommendations. Let's implement the Punchi Commission recommendations. Let's look at the terms and reference of the 16th Finance Commission. That can be consulted using interstate council. So interstate council is a non-permanent body because Constitution says, dear President, if at any point it appears to the President that public interest would be served by the establishment of a council called interstate council, you can create that interstate council. And such councils have been created in the past. Created and then abolished. There was a time when interstate council on local government, interstate council on taxes was also constituted. But then the interstate council with the name interstate council was established in 1990. Clear? Few important things. And sometimes these things are directly asked in the prelims examination. No tax shall be levied or collected except by the authority of law. Can the central government, can Nirmala Tai, Honorable Finance Minister, issue a notification and through that impose tax? No. It has to be done through a law. It cannot be done through a notification, through a regulation. No. By the authority of the law. Article 266 then creates two constitutional funds. One is the Consolidated Fund of India. One is the Public Account of India. There is a consolidated fund for every state. There is a public account for every state. These are constitutional funds. almost the entire money that is generated by the government of India gets deposited in this consolidated fund. For example, the loans that the government of India raises, the investments, corporate tax, income tax, all the taxes that are raised, generated, the revenue from these taxes gets deposited in the consolidated fund of India. And this consolidated fund of India is operated through parliamentary law. Parliament is the custodian of this consolidated fund, which means the executive cannot withdraw even a single penny from consolidated fund of India without getting an appropriation bill passed, without getting the permission, approval of the parliament. But public account of India is kept under the control of the executive, under the purview of the executive, which means executive can withdraw money from public account of India at any point in time without the need of a parliamentary approval. And public account of India consists of money other than which is deposited in consolidated fund. For example, judicial deposits, pension deposits, they get deposited in the public account of India. But then we have Article 267, which talks about contingency fund. But listen to me carefully. Contingency fund is a statutory fund created by the Contingency Fund of India Act 1950. Sometimes we may not get the approval of the parliament, or parliament is not in session, but we need money, and that money we need now. Maybe public account of India is not sufficient enough. Then we can withdraw, the executive can withdraw money from Contingency Fund of India, which is kept at the disposal of the President of India. So then why it is a statutory fund? Because Constitution itself says, what is contingency? For emergency needs. Contingency as an English word. Constitution says Parliament may by law establish a contingency fund. And then Parliament established a fund and named it Contingency Fund of India. It is in the form of an imprest, in the sense money will be there in consolidated contingency fund. This will be for emergency need. When we don't have money in public account or we can't get the parliamentary approval. For example, we need supplementary grants, excess grants, or for that matter, vote on account. We can withdraw money from contingency fund, but then it has to be replenished. For example, if it consists of 500 crores and we have withdrawn 200 crores, then 200 crores we need again from consolidated fund. So we will pass an appropriation bill, withdraw money from consolidated fund, deposit back into the contingency fund so that this fund is full again. Long story short, if we need money right now, we will withdraw from contingency fund, and then once we have the money from the parliament, we will deposit that money back into the contingency fund so that it is back again. But Contingency Fund of India is a statutory fund. It is not a constitutional fund. There are a lot of provisions in the Constitution related to taxes. For example, there are certain taxes which are imposed by the center but collected by states and assigned to states. There are some taxes which are imposed by the center, collected by the center, but distributed with the states, shared with the states. For example, income tax, corporate tax. Those matters Sham sir would be discussing in his classes, because then there is a lot of overlap between some provisions which are there in economics and some provisions in polity. So normally I leave this matter to Sham sir. Sham sir will discuss them beautifully in his classes. But remaining points we will discuss briefly, then we will take a break, and then we will return from a break and then discuss other provisions. For example, Article 280. The President shall First, within 2 years from the commencement of the Constitution, that means in 1952, and then every 5 years, at the expiry of every fifth year, constitute a finance commission. And Constitution itself says that it will consist of chairman and 4 other members who will be appointed by the president. What will be the role of the finance commission? For example, this money that is there in Consolidated Fund of India, or for that matter, divisible pool of taxes. Income tax, corporate tax, the proceeds are deposited in Consolidated Fund of India, but these are to be shared with the states. What is that percentage? Should it be 41%? Should it be 42%? Terms of reference are decided by the central government for this finance commission. For example, should we sell our non-performing public sector undertakings? Should we go for disinvestment or privatization? How do we charge for essential goods, for example, public goods, for example, water, electricity? That finance commission will have to tell us. But one more important thing for your exam is that a recommendation of the finance commission is not binding on the government. But since it is a constitutional body, we defer to the finance commission. We accept the recommendations of the finance commission. But it shall be the duty of the president. That, dear president, what is your duty? Whenever the report of the finance commission is made, you have to table this report on the floor of the parliament. Not only is the report to be tabled on the floor of the parliament, you also have to table ATR, action taken report. Action taken report in the sense, what are these recommendations of the finance commission and what action have you taken? The explanatory memorandum, whether some recommendations you have accepted and some you have not. And if you have not accepted, tell us the reason why. Action taken report. This is also the constitutional mandate. President, remember this, will not only have to table finance commission recommendations on the floor of the parliament, but also has to table action taken report. What exactly is the action that you took, that your government took on these recommendations? Few important facts, please remember them carefully, memorize them. There's a property of the union, and this union property is in Karnataka or in Tamil Nadu. It is exempt from the tax imposed by the state. Neither can the Tamil Nadu state nor the Karnataka state or the local bodies of Karnataka and Tamil Nadu impose a tax on this union property. But Parliament may by law otherwise provide that, yes, states, you can impose tax on these properties. Otherwise, no. The property of the union cannot be taxed by the state or any authority within that state. Similarly, the taxes on electricity. Very important point. On electricity, there is a lot of debate and discussion going on for the last few months. There was something related to Karnataka as well. I hope you're reading newspapers. There is something called the newspaper, by the way. And there is something called the Hindu or the Indian Express, which you must read for the exam. It was mentioned there. Parliament may by law otherwise provide that no law of the state shall impose a tax on the consumption or sale of electricity, whether this electricity was produced by the government of that state or any other person, maybe private as well. Parliament may by law provide that state cannot impose any tax on this electricity or empower some other authority, for example, local authorities, to impose a tax on electricity if this electricity is consumed by the government of India. If this electricity is sold to the government of India, if this electricity is consumed in constructing railways, in maintaining railways, then no tax can be imposed on electricity by the states. Otherwise, on electricity, states can impose taxes, but not on the electricity which is sold to the government, which is consumed by the government of India for the maintenance of railways. It's a very important provision under Article 287. But sir, if the property of the union cannot be taxed by the state, what about the property of the state? Can it be taxed by the union? Can union taxes be imposed? The property and income of a state shall be exempt from union taxation. In other words, we can say corporate employees have to pay 30% tax. Corporates have to pay less than that, sometimes 15, sometimes 0. And government has to pay no tax at all. So the tax burden is on we, the people of India. And if you have to then sue the government, Indra Sani v. Union of India, Keshavananda Bharati v. State of Kerala, Bachchan Singh versus State of Punjab, S.R. Bommai v. Union of India. So Union of India and State of Kerala, State of Punjab, State of Maharashtra, Milind versus State of Maharashtra 2000. This is provided in Article 300 because you can sue the government. The government of India may sue or be sued by the name of the Union of India. The government of the state may be sued or may sue by the name of that state. Keshavananda Bharati versus State of Kerala. S.R. Bommai v. Union of India. Where is it mentioned? It's mentioned under Article 300. Then Article 300 capital A, which was previously a fundamental right. But 44th Constitutional Amendment Act 1978 converted this fundamental right into other constitutional right. Right to property. And read this carefully. No person shall be deprived of his property save by the authority of law. So what does that mean? That means through government regulation, through notification, through a cabinet resolution. You cannot deprive somebody of the property. If you have to deprive somebody of the property, that can be done only by the law. Sir, what is the significance of this for the civil services examination? Look at the previous year's question, which was asked in 2021, on which there was a lot of confusion by the students. What is the position of the right to property in India? It is neither a fundamental right nor a legal right. It is clearly false because it is a legal right, a constitutional right under Article 300 capital A. It is a fundamental right available to citizens only. It used to be a fundamental right under Article 19, and you would know that all these fundamental rights under Article 19 are known as the natural rights, and these natural rights are available only to the citizens of India. Now there is a confusion whether it is legal right available to citizens only or legal right available to any person. What does the Constitution say under Article 300 capital A? No person. It does not say no citizen. So which means it is a legal right available to any person. B is the right answer. This is the significance of the Bear Act. This is how lines, statements have been asked in the examination, as if these lines and statements have been directly lifted from the Bear Act. It is 10:13. We'll take a break. We will come back at 10:30 and discuss the remaining provisions of the Bear Act. So stay with me till the end. We will comprehensively cover this Bear Act so that there is no need for lecture 4 and there is no need for you to read this Bear Act on your own. See you on the other side of the break. Don't go away. Now let's continue and let's look at part 14 of the Constitution, services under the Union and the states. What does Article 309 talk about? If it's a service under the Union and if it's a service under the state, who has the power to regulate the service conditions, the terms? For union posts, it is the Parliament. For states, it is the respective state legislature. That means the acts of the appropriate legislature. Appropriate legislature means for the union, appropriate legislature is the Parliament. For the states, appropriate legislature is the concerned state legislature. And by passing a law, Parliament for union posts, state legislature for the state level jobs may regulate the recruitment, service conditions, so on and so forth. That is Article 309. Article 310 says, if you are a part of central services, then you hold office during the pleasure of the President. For example, if you are part of the state services, you hold office during the pleasure of the governor. But what about All India services? How many All India services do we have? 3. We have Indian Administrative Service, Indian Police Service, and Indian Forest Service. You are all aspiring to become an All India service, IAS, IPS. IFS is a central service. You will be holding office during the pleasure of the President. That is something which is mentioned under Article 310. Then Article 311 talks about dismissal, removal, or reduction in rank. If you are dismissed from the service, you are ineligible for a government job. If you are removed from the service, you are, although, eligible for a further recruitment under the government. Your rank can also be reduced. But who can dismiss you? Who can remove you? Who can reduce you or reduce your rank? This cannot be done by somebody who is subordinate to the one who has appointed you. Which means if you have been appointed by the President, President has the power to dismiss you, to remove you, to reduce your rank. If you have been appointed by the Governor, only the Governor has the power to remove you, reduce your rank, or dismiss you from the service. This is something which is covered under Article 311. But even if you are to be removed or dismissed, or your rank is to be reduced, for that there has to be an inquiry. Without an inquiry, you cannot be dismissed, you cannot be removed, you cannot be reduced in your rank. Inquiry is a must. But there are 3 ways in which even this inquiry is not required. Which are these 3 ways? For example, you have been convicted by a court of law. And because of that conviction, you have been sentenced to, let's say, 10 years in jail. For that, you have also violated your service conditions. Which means you have violated your service conditions. You have been convicted by a court of law. Now we will dismiss you without any need for an inquiry. Why? Because there is no need to conduct an inquiry because the courts have convicted you for some illegal activities. For example, terrorism. For example, corruption. Then even without an inquiry, you can be dismissed or you can be removed or your rank can be reduced. But sometimes the authority which has the power to remove you, for example, the authority which has the power to remove you can be the director of your organization or can be the head of your organization, HOD, head of the department. Sometimes you can be reduced in rank or dismissed or removed from the service even without an inquiry. But the appointing authority has to say in writing why it is not possible to organize to hold an inquiry. Or third way, president or the governor will say that it is not possible to even hold that inquiry. And you are removed, dismissed, or reduced in your rank. So Article 311 gives some constitutional safeguards to these members who are part of the services, which means you cannot be reduced in rank, you cannot be removed, you cannot be dismissed without an inquiry. Inquiry is a must. But then there are exceptions. Inquiry is not required if you have been convicted by the courts of law. Inquiry is not required if the authority which is responsible for removing you gives us in the writing why we are not conducting an inquiry. But then there is a third case where the president or the governor says that it is not possible in national interest to organize to hold an inquiry. That means even without an inquiry, you can be removed, dismissed, or your rank can be reduced. That is Article 311. Then we have Article 312, which talks about an all India service. Constitution says that Indian police, which is the predecessor of Indian police service, or Indian civil services, which is the predecessor of Indian administrative service, because it used to be called ICS, Indian civil services, IP, Indian police. Article 312 said, this Indian administrative service and this Indian police may be considered to be the posts created by the Constitution. Sardar Patel was instrumental in giving constitutional status to all India services, and that is why Sardar Patel is known as the father of all India services. Then Indian Forest Services was also created. But how can we create a new All India service? Rajya Sabha, Council of States, we say it represents the interests of states. In Parliament, because these All India service officers, they are appointed by the union, removed and accountable to the union. They are trained by the union, but they work in the states. So we can say that All India services, these are a centralizing tendency in Indian federalism. It goes against the grain of federalism to have all India services in India, because these are the officers who are appointed by the center, trained by the center, recruited by the center, accountable to the center, but working in the states. Can we create another all India service? But for that, Rajya Sabha should pass a resolution. Now the question is, who can create a new all India service? For example, if we need an Indian all India service on education, if we need an all India service in health, who has the power to create that new all India service? That power is available with the Parliament. But Parliament cannot create a new all India service unless and until the Rajya Sabha passes a resolution by not less than 2/3 of the members present and voting, that it is necessary in national interest that we create a new all India service. Then Parliament will create a new all India service. Long story short, a new all India service can be created only by the Parliament. That means both Lok Sabha as well as Rajya Sabha, and assented to by the President. But Parliament cannot initiate this process of creating a new All India service unless and until the Rajya Sabha, which represents the interests of the states in Indian Parliament, passes a resolution by not less than 2/3 of the members present and voting, saying it is expedient in national interest, necessary national interest to create a new All India service. For example, All India Judicial Service was created by the 42nd Constitutional Amendment Act 1976. And it says this All India Service will not have a post less than a district judge. But this constitutional amendment has not been notified yet. But All India Service has been created using the power under Article 312. That is something very, very important for your examination. And then Article 315, it talks about public service commissions for the union and for the states. Constitution says there shall be a public service commission for the union and public service commission for each state. 2 or more states, which means one, we will have UPSC at the union level, Union Public Service Commission. We can have State Public Service Commission as well, for Jharkhand, for Tamil Nadu, for Karnataka, for Maharashtra. Both these are constitutional bodies. But then 2 or more states can have a joint service commission. And that joint service commission is a statutory body. This identification is very important. Which is a constitutional body, which is a statutory body. UPSC State Public Service Commissions are constitutional bodies. But 2 or more states may pass a resolution saying, Parliament, you create a joint service commission for us. And that is referred to as a joint commission. But now, interesting thing, important thing. What if Karnataka and Maharashtra wants to have a joint state public service commission? Both Karnataka as well as Maharashtra, they have a bicameral legislature. That means 2 houses, Legislative Assembly, Legislative Council. Should such a resolution be passed only by Legislative Assembly or by both the houses? Constitution says should be passed by both the houses if there is a state where we have a bicameral legislature. So both houses of Karnataka, both houses of the Maharashtra legislature will pass a resolution requesting the Parliament that their Parliament please create a joint state public service commission, and that will be a statutory body. But sometimes there may be a state which will say that we will not have a state public service commission. We are requesting UPSC, you become the recruiting agency for us. And if a state government requests the president, this request has to come from the governor of a state, and the governor will request the president. President will approve it. Then UPSC can become the recruiting agency for that state. For some years, Haryana had utilized the services of the Union Public Service Commission so that UPSC can serve the needs of the recruiting agency for the state of Haryana. This is something that you have to keep in mind. But something else as well. The chairman and other members of a public service commission shall be appointed by whom? If it's a UPSC, it will be appointed by the president. If it's a state commission, it will be appointed by the governor of that state. Where is it mentioned? Article 316. But what about the chairperson and members of these public service commissions? Listen to me carefully. Who appoints the chairperson and members of UPSC? President. Who appoints the chairperson and members of the State Public Service Commission? Governor. But who can remove them? The removal is by the president. So even the chairman and the members of the State Public Service Commission can be removed from their offices only by the president. But how? One, it can be on the grounds of misbehavior. So if the allegation against a chairperson or a member is that you are accused of misbehavior, which can be corruption, which can be sexual misconduct, anything, then there has to be inquiry by the Supreme Court. Supreme Court has to conduct an inquiry. And after the inquiry by the Supreme Court, if the Supreme Court says, yes, this chairperson or the member should be removed, President shall remove the chairperson and the members. This is if the allegation against the chairperson or the member is that of misbehavior. But then there are other grounds. Other grounds such as, if you indulge in paid employment outside your office, if you have been adjudged insolvent because of the infirmity of mind or body, in these cases, there is no need for a Supreme Court inquiry. Sir, what are you saying? I am saying, now that the chairperson and members of the UPSC are appointed by the President, and the chairperson and the members of the State Public Service Commission are appointed by the governor, but they can also be removed. Where is it mentioned? Constitution, Article 317. Constitution says the chairperson and member of whether UPSC or State Public Service Commission can be removed by the President. If the allegation is misbehavior, then this matter has to go to the Supreme Court. Supreme Court will conduct an inquiry if the allegation is misbehavior. But there can be other grounds on the basis of which the chairperson and members can be removed. And these other grounds do not need inquiry by the Supreme Court. For example, if you have indulged in paid employment outside your office, for example, the UPSC chairperson gets money from Unacademy. Unacademy pays well. That prelims examination paper, or what is the criteria on the basis of which you do this, you do that, you decide the candidature. So if you are engaging in paid employment outside of your office, there is a conflict of interest, you can be removed by the President. And this time we don't even need the inquiry by the Supreme Court. If you have been declared bankrupt, then again there is conflict of interest, you can be removed even without an inquiry. Or infirmity of mind or body. When you were appointed as the chairperson or the member of the UPSC or State Public Service Commission, you were healthy, both mentally as well as physically. Now, mentally, you have turned insane. You have gone insane. We may have sympathy with you, but we cannot entrust you with the responsibility of this commission. And we will have to remove you even without an inquiry by the Supreme Court. This is mentioned under Article 317. Now, something else. Very, very important points. We have UPSC chairman. We have a UPSC member. We may have a State Public Service Commission chairman. We may have a State Public Service Commission member. We may have a joint State Public Service Commission chairperson. And we may have a joint State Public Service Commission member. Right or wrong? This UPSC chairman, I'll use a different highlighter. This UPSC chairman is ineligible. Once your term is over, for example, you are appointed UPSC chairperson, your term is 65 years or 6 years, whichever is earlier. State Public Service Commission, your term is 62 years or 6 years, whichever is earlier. Now, once your term is over, you are ineligible for further employment under the Government of India or Government of a state. You cannot be appointed again. But what if you are a UPSC member? You can be appointed as a chairman. You cannot be appointed for a member again. You can be eligible only for the chairperson, not the member. Now we have a State Public Service Commission chairperson. He is eligible to be appointed as either the chairman or the member of the UPSC, but not for any other government post. Or you can also be appointed as the chairperson or the member of other states' Public Service Commission, but not your own state, because once you are the chairman of your state Public Service Commission, you cannot be further appointed as the chairman. That means you're ineligible for reappointment. If you are a member of the State Public Service Commission, you are prohibited, ineligible to be reappointed as a member. But you can be appointed to UPSC. You can be appointed to any State Public Service Commission. Similarly, member other than the chairman of the UPSC shall be eligible to become the UPSC chairperson, but not for any other post, neither under the government of India nor under the government of the state. Which means, can this UPSC member become a State Public Service Commission chairman or member? No. You are only eligible for a UPSC chairman's post, nothing else. Now, there can be a member other than the chairman of the State Public Service Commission. This member of other State Public Service Commission, you are eligible to become the member of the UPSC chairman or UPSC member, or as the chairman of any other State Public Service Commission, but not for any other employment, either under the government of India or government of that state. Long story short, UPSC chairman ineligible for further employment. UPSC member eligible for UPSC chairman, nothing else. State Public Service Commission, State Public Service Commission member, ineligible for chairman and member of that commission, but eligible for member or chairman of UPSC, eligible for member or chairman of other State Public Service Commission. This is mentioned where? Under Article 319. This is to ensure there is no, that these constitutional entities, they function with independence. Otherwise, their independence would be lost. All the expenses of the UPSC, including their salaries, emoluments, they will be charged on the Consolidated Fund of India. And when any expense is charged on the Consolidated Fund of India, you know that Parliament does not have the power to vote on those expenses. Yes, Parliament can discuss. Similarly, the salary, the allowances of the State Public Service Commission shall be charged on the Consolidated Fund of that state. This is again to ensure independence of these constitutional entities. Another important thing, what about the reports? UPSC will submit annual report. To whom? To the President. State Public Service Commission will send its annual report to whom? To the Governor of the state. Now, Governor will get the report of the State Public Service Commission. President will get the report of the Union Public Service Commission. Now it's the duty of the President and the Governor that you have to lay these reports on the floor of the legislature. That means President will lay down this report on the floor of the Parliament. Governor will lay down this report on the floor of the state legislature. Not only report, ATR as well, just like Finance Commission. What are the recommendations of the Union Public Service Commission which the central government, union government did not accept? And why you did not accept those recommendations? What are the recommendations of the State Public Service Commission which the state government did not accept? So apart from these annual reports, the action taken reports also are constitutionally mandated on part of the President and the Governor to lay down before the Parliament. And then I told you, Part 14 capital A, related to tribunals. These tribunals were not originally part of the Constitution. These were added by the 42nd Constitutional Amendment Act, 1976. And why these tribunals were established? You can call them quasi-judicial bodies. Why quasi-judicial bodies? Because these tribunals will have judicial members, will have experts as well. Experts are from non-judicial background. That means the composition is such that it does not only consist of members from the judiciary, from non-judiciary as well, which makes it a quasi-judicial body. And their job is to resolve disputes. And these resolution of disputes are swift, and they lower the burden on ordinary courts. When we will discuss content related to the mains examination, we will discuss that tribunalization has been an issue. And through this tribunalization, you are basically reducing the sanctity of the high courts. But that is something that we will discuss for the mains examination. For the prelims examination, you need to know that these tribunals are quasi-judicial entities. They have judicial members as well, non-judicial experts as well. But since they are resolving the disputes, we call them quasi-judicial bodies, and their purpose is to reduce the burden on the high courts. Two articles were inserted because of this 42nd Constitutional Amendment Act, Article 323 capital A, which deals with administrative tribunals. For example, tomorrow, once you become an IAS officer or an Indian Foreign Service officer, there may be problems, disputes that you may have with Department of Personnel and Training, with Department of Home Affairs, Ministry of Home Affairs, with maybe Ministry of Environment, Forest and Climate Change, with maybe Ministry of External Affairs. You will have disputes, you will have problems. Instead of going to the regular court, you can approach the CAT, Central Administrative Tribunal. Similarly, at the state level, we have SAT, State Administrative Tribunals. So 323 capital A talks about administrative tribunals for these administrative matters related to the service conditions, maybe promotion of these civil services. Then 323 capital B talks about tribunals for other matters. These administrative tribunals can be created only by Parliament. But tribunals for other matters can be created by appropriate legislature, which means these tribunals for other matters can be created by the state legislature as well, for Parliament as well. For example, for what matter? Maybe for election disputes. Maybe for sealing on urban property. Maybe for labor disputes. Maybe for rent. That means on other matters, apart from the administrative matters, which means apart from administrative tribunals, there can be tribunals on other matters, which can be created by the appropriate legislature, which means by the Parliament as well as by the state legislature. For example, state legislature may create a tribunal for labor disputes within that particular state, or an election dispute to resolve the disputes when it comes to the election for the local bodies. Or the Parliament may set up an election tribunal, which means when you have a dispute with respect to an MLA election or an MP election, instead of going to the High Court, you can go to the election tribunal. Although these tribunals have not been set up, but 323B talks about tribunals for other matters. Other matters, apart from the matters which we have discussed previously, called administrative matters. That is tribunals under Part 14, capital A. Then we have Part 15, which deals with elections. Elections, the biggest festival in India. So the biggest festival in a secular democracy may not be Holi, Diwali, Eid, Baisakhi, Christmas. But these are elections. And through these elections, we ensure representative democracy. Because ours is not a direct democracy. We basically elect our representatives. And then these representatives make laws for us and govern us. And elections have to be free, fair, and periodic. Free election, whoever is eligible to contest election should be allowed to contest election. It should be free for all the eligible candidates. Whoever is eligible to vote should be allowed to vote freely. And then election should be fair as well. Fair in the sense, although I voted, but I voted for A and this vote went for B. Although it was a free election, but it was not fair because the outcome has been nullified. And election has to be periodic as well. It should be conducted after every period. Can we say that elections in India are periodic if they are conducted after every 50 years? No. Periodic means it should be conducted within a period of 5 years. Is a functional democracy. Otherwise, elections happen in Russia as well. Look what has happened in Turkey, where an important opposition leader, the mayor, was arrested on corruption charges, and now Turkey is on boil because of the protests. So elections have to be free, fair, and periodic. That will tell us whether the country is a functional democracy or not. And for that, we have some constitutional provisions. For example, Article 324 creates a constitutional body known as the Election Commission of India. And Constitution says superintendence, direction, conduct, and control of all these elections, whether elections are to Legislative Assembly or Legislative Council, Lok Sabha or Rajya Sabha, President or the Vice President, it shall be conducted by this body called Election Commission of India. And the very presence of Election Commission of India tells us that we have a quasi-federal constitution, or should we say a constitution with a unitary bias. Because even to the state legislatures, election is conducted by a body which is a union body. States do not have their own election commissions. Yes, states do have their own election commissions, but only for the conduct of local elections, Panchayats and municipalities. Otherwise, for the state legislatures also, Election Commission of India is the body. But this Election Commission of India will consist of Chief Election Commissioner and as many election commissioners as may be appointed by President. This is mentioned in the Constitution. But if Chief Election Commissioner and election commissioners are appointed by the President, on what grounds? How? For that Constitution envisaged that Parliament will enact a law. Because Constitution, what does it say? That we will create a body, a constitutional body called Election Commission of India, which will have the power of superintendence, direction, conduct, and control of all elections. And this Election Commission of India will consist of Chief Election Commissioner and as many election commissioners as may be appointed by the President. But how President will appoint them? On what basis? On what grounds? After consulting whom? For that, a law had to be passed by the Parliament, which was not passed. And it was not passed since 1950. Continued, till the matter went to the court. Anu Baranwal v. Union of India. Supreme Court said, yes, the current system of appointment is such that it violates free and fair elections. It violates Article 14. How does it violate Article 14? Because Article 14 also talks about right against arbitrariness. And the president is arbitrarily appointing the chief election commissioner and the election commissioners. Arbitrarily in the sense, it is biased in favor of the ruling party, which may compromise free and fair election. And in this Onu Baranwal case, Supreme Court said, till the time Parliament enacts a law, this chief election commissioner and election commissioners shall be appointed by the president, because we can't rewrite the constitution, but president will appoint CEC and election commissioners based on the recommendations of a committee consisting of Prime Minister, Leader of the Opposition in Lok Sabha, and the Chief Justice of India. Then within no time of this judgment, Parliament enacted a law and said instead of Chief Justice of India, the third member would be a cabinet minister. Nominated by the Prime Minister. This matter is before the court. Let's see what the court will have to say on this matter. Because even with this committee now, it is still arbitrary, violating Article 14 because it is skewed in favor of the executive. That means it's just like the system that we had prior to Anu Baranwal judgment. But be that as it may, that's for the courts to decide. But Constitution does say that this chief election commissioner shall be removed by the president in the same manner and on the like grounds as the judge of the Supreme Court. On what grounds is the judge of the Supreme Court removed? Through misbehavior and incapacity. This is the ground. What is the manner? Both houses of the Indian Parliament will have to pass a resolution by a majority of not less than 2/3 of the members present and voting, and the majority of the total membership of the House, which means that resolution becomes a statutory resolution. And those who have studied polity with me, you would know that resolution is of 3 types. There is a government resolution, there is a private member's resolution, and there is a statutory resolution. And it is only this statutory resolution which is binding on the government. Right? And these election commissioners are to be removed by the president, but only on the recommendation of CEC. That's Article 324. 325 talks about a common electoral roll. For example, euphemistically, it was called Morley-Minto Reform of 1909, which created something called communal electorates or separate electorates, initially for Muslims and then extended to Sikhs, extended to Christians, extended to Anglo-Indians, later on got extended for Dalits as well, but this is where Mahatma Gandhi protested. He went on fast unto death, and then you would know the rest of the story. The Pune Pact was signed between Mahatma Gandhi and Dr. Ambedkar. And because of that, communal electorates for Dalits was discarded, although the seats reserved for Dalits got increased. But there were separate electorates where only the Muslims could contest elections and only Muslims could vote. So there were separate electorates. Article 325 says, because the constitution makers realized that we cannot afford that in the independent India. We cannot afford another partition of this country. That is why there has to be a common electoral roll. And nobody shall be denied admission into this common electoral roll only on the grounds of religion, race, caste, sex, or any of them. That means for different religions, different electoral rolls? No. For different genders, different electoral rolls? No. For different races, for different castes? No. But then, sir, why is there reservation for SCs and STs in Lok Sabha and legislative assemblies? That was meant for only 10 years. But each time that 10-year period gets expired or is about to get expired, the parliament extends it for another 10 years. But that is not a separate electorate as we saw during the Modelimento reforms, because although the seats are reserved for Dalits or tribals, but anybody can vote. Non-Dalits, non-tribals can also vote during those elections. Common electoral roll. And then we have a universal adult suffrage. Article 326, which tells us about right to vote. So this right to vote becomes a constitutional right, according to UPSC. Although in reality, it should be a statutory right, because this is the right provided by the law passed by the Parliament called Representation of the People Act 1951. But be that as it may, initially the voting age used to be 21. But then in 1988, Constitution was amended, 61st Constitutional Amendment Act, and voting age was lowered from 21 to 18. Clear? And maybe it is time to further lower it to maybe 16 or 14. But that's a separate matter altogether. Article 327 and 328 are more or less the same. 327 and Article 328. 327 empowers the Parliament. 328 empowers the state legislature. That you can enact laws for the conduct of elections. You can enact laws for the conduct of elections. Elections where? Parliament and state legislature. Elections where? To your own state legislature. And this is how Parliament has enacted a law. For example, Representation of the People Act 1950. Representation of the People Act 1951. President and the Vice President's Elections Act. But can state legislature also enact a law? For example, Karnataka legislature enacts a law for the conduct of elections to Karnataka legislature. Yes, provided Parliament has not made such a law. But since Parliament has already made a law, that means it is this parliamentary law which governs the conduct of elections even to the state legislatures. Long story short, Article 327 gives power to the Parliament that you can enact a law for the conduct of elections to Parliament and state legislatures. 328 empowers the state legislature that you can also make a law for the conduct of elections to your own state legislatures. For example, you can define the qualification of voter. You can define qualification of the candidate, disqualification of a voter, disqualification of a candidate, provided Parliament has not enacted a law on that matter. Since Parliament has already done that, that means this Article 328 has not been invoked by the states. And Article 329 talks about bar to interference by courts in electoral matters. And which is that electoral matter? Delimitation. Whenever a delimitation order is issued by the Delimitation Commission or Election Commission of India, it cannot be challenged in any court of law according to Article 329. although there is a 2024 Supreme Court judgment which says, yes, even that delimitation order can be challenged in the court of law if it is nullified, arbitrary. Because, long story short, keep that in mind, we can safely say that there is nothing beyond the scope of judicial review. Anything and everything can come under judicial review. Sir, even if it is explicitly prohibited by the Constitution, yes. Did we not discuss Article 262, where we said that Parliament can enact a law, and through that law, it can adjudicate interstate river water disputes, and by enacting a law, exclude the jurisdiction of the court, the Supreme Court? But even then, Supreme Court is hearing interstate river water disputes. Why? Because Supreme Court says and gives a lot of reasons. Supreme Court says that on this interstate river water, water is also a means, an important source of livelihood. Right to livelihood is a fundamental right. And if there are people approaching us for the violation of fundamental rights, we can't shoo them away. Similarly, Supreme Court has said that we will not exercise original jurisdiction. Whenever the Interstate River Water Tribunal will give an award, we can review it. Explicitly, it is mentioned in the Constitution regarding Article 110, Money Bill. The definition of Money Bill provided under Article 110. The procedure of Money Bill mentioned under Article 109, where Constitution is categorically clear and explicit that the certification of a money bill by the Speaker shall be final and binding, which means you cannot challenge this in a court of law. But Jairam Ramesh, Congress politician, approached the Supreme Court along with others, challenging the introduction of Aadhaar as a money bill, and that matter is still pending before the court. For that, the Supreme Court Chief Justice has to set up a 7-judge Constitution bench to review it. So what are you trying to say? I'm saying you can safely assume that there is nothing beyond judicial review, because judicial review is part of the basic structure of the Constitution. Sir, even if it goes against the articles mentioned in the Constitution, yes. Why, sir? Because Supreme Court is the final interpreter of the Constitution. Because if the executive is violating the Constitution, if the legislature is violating, you go to the Supreme Court. But if the Supreme Court seems to be violating the Constitution, where will you go? Supreme Court is the final interpreter of the Constitution. And then there is a definition of the Constitution. What is a Constitution? Constitution, yes, a supreme law of land which enjoys special legal sanctity. Constitution, yes, a document of people's faith and aspirations. Constitution, yes, which allocates roles and responsibilities to different organs. Constitution, yes, which imposes a limitation on the powers of the state. But then there is an apt definition of the Constitution. Constitution is what Supreme Court says it is, because the final interpreter of the Constitution is the Supreme Court. Okay? President's pardoning powers can also be challenged in the court. Yes. My polity lectures can be challenged in the court of law. Let's look at Part 16 of the Constitution. Special provisions relating to certain classes. Remember when we discussed PCS, TISO, EMAS, that acronym which you can use to memorize these parts. And I told you it's a special provision for certain classes, not for certain states. That we will discuss separately. Classes in the sense, a reservation of seats for scheduled castes and scheduled tribes and House of People. Where is it mentioned? Article 330. That means scheduled caste and scheduled tribes, these are certain classes of people. And for them, there are special provisions. Similarly, reservation of seats for women in the House of the People. Article 330, capital A, which was inserted by the 106th Constitutional Amendment Act, 2023. But this Constitutional Amendment Act is not in force. Why? Because for that we need to conduct the census exercise first, then we need to conduct the delimitation. When the census and delimitation is over, only then this 106th Constitutional Amendment Act will enter into force. So women are treated different class, and for this class special provision, just like special provision for SCs, STs, women and Anglo-Indians. Constitution says, if the president is satisfied that the members of the Anglo-Indian community are not sufficiently represented in the parliament, in the Lok Sabha, then the president may nominate 2 members from Anglo-Indian community to the House of the People, to the Lok Sabha. Not more than 2. But sir, what about others? Reservation of seats for SCs and STs and legislative assemblies as well. Similarly, reservation of seats for women in legislative assemblies as well. But sir, we don't have reservation for Anglo-Indians now. Yes, that is true. Why? Because Constitution says that originally this reservation for SC, ST and Anglo-Indian community was meant to be for 10 years. That means from 1950 to 1960. When it was about to get expired, Constitution was amended again to extend it for another 10-year period. That means extend till 1970, then extend till 1980, then extend till 1990, then extend till 2000, 2010, 2020, which means 10, 20, 30, 40, 50, 60, 70 years. When it was about to expire in 2020, 104th Constitutional Amendment Act was provided. To say what? To say that for SCs and STs, it will be extended for 80 years. That means till 2030. But for Anglo-Indians, it will be only for 70 years. Which means now, because of 104th Constitutional Amendment Act, this reservation period for SCs and STs got extended by another 10 years. But this was not extended for Anglo-Indians. That means Anglo-Indian reservation ended after 70 years of the enactment of the Constitution, of the commencement of the Constitution, and it will continue for 80 years for SCs and STs. Will it be further continued and extended in 2030? We will have to wait and watch. In all likelihood, it will be extended. Then Article 335. We have discussed in classes Indira Sani v. Union of India, where what was challenged before the court? The OBC reservation. Because when the VP Singh government decided to implement the Mandal Commission report and provided 27% reservation for other backward classes in government jobs, matter went to the court. Indira Sani v. Union of India. By the time the court heard this matter, the government had changed. Narasimha Rao had become the Prime Minister, and Shri Narasimha Rao decided through a government order, through a regulation, that 10% jobs shall be reserved for poor as well. Matter went to the court, and Supreme Court had to decide whether this is constitutional or not. Supreme Court said in Indira Sani case, the Constitution bench said, reservation for poor of 10% is unconstitutional. Why? Because Constitution recognizes backwardness on only 2 grounds, social and educational backwardness. Reservation cannot be extended for economic backwardness. But court allowed OBC reservation. But court said you have to meet 5 constitutional requirements. Number 1, you have to prove that these OBCs that you have created, these are socially and educationally backward. Number 2, you have to convince us, prove us through data, through a study, that these OBCs are not adequately represented in the administration. Number 3, you have to ensure that reservation does not exceed 50% unless and until there is an extraordinary circumstance. Number 4, you have to ensure that concept of creamy layer shall apply. Those who are part of creamy layer amongst OBCs, they will not get the benefit of reservation. But those who are part of non-creamy layer, some criteria was set up. Initially, it was 2.5 lakh. Now it is 8 lakh. And property and land. That means some economic criteria has got ingrained into this backwardness. And 5th, the Supreme Court said, efficiency of the administration cannot be flirted with. That means this OBC reservation is subject to Article 335. And what does Article 335 say? There will be claims by the members of the SC and ST community. They will claim government jobs. And their claims have to be considered, but keeping in mind the efficiency in administration. But what is this efficiency of administration? It is not defined in the Constitution. That is why this question was asked in your Prelims 2023. Look at the question on your screen. Consider the following statements. Statement 1, the Supreme Court of India has held in some judgments, for example, Indira Sani, that the reservation policies made under Article 16, Clause 4 would be limited by Article 335 for the maintenance of efficiency in administration. This is correct. Article 335 of the Constitution defines the term efficiency of administration. It does not. So statement 1 is correct, statement 2 is incorrect. So C is the right answer. Right or wrong? I remember my father told during the OBC reservation, one DU student burnt himself in the North Campus. His name was Mr. Goswami, not the other Goswami, the chief priest of the nation, and the nation does not want to know. Okay. Now there are 3 more constitutional bodies created. Initially, there was a common constitutional body called National Commission for the Scheduled Caste and Scheduled Tribes. But then bifurcation happened because of the 89th Constitutional Amendment Act 2003. Bifurcation in the sense, this National Commission for Scheduled Castes and Scheduled Tribes got bifurcated into National Commission for Scheduled Castes, National Commission for Scheduled Tribes. National Commission for Scheduled Caste under Article 338, 338 capital A, National Commission for the Scheduled Tribes. The National Commission for Backward Classes, for example OBCs, it was initially a statutory body. But then it was given a constitutional status. When? Because of the 102nd Constitutional Amendment Act. And because of the 102nd Constitutional Amendment Act, Article 338 capital B was inserted into the Constitution, and another constitutional body was created called National Commission for Backward Classes. Let's look at Article 341. For example, Métis. There's a conflict between Métis and Kukis in Manipur. Although the grievances are old, historic, but the immediate trigger of the crisis was the Manipur High Court order, which directed the Manipur government that you should consider granting ST status to Métis, and that too preferably within 1 month of the receipt of this order. This was considered, although not correctly, this was considered as if the High Court of Manipur has granted ST status to Métis or has forced a state government to grant ST status to Métis. where that was not the case. It was only the High Court asking the state government to take it up with the central government to consider giving ST status to Métis, because Métis till now they have SC status as well. Some of them have OBC status as well. But what is the process of granting one an SC status or an ST status? This can be done by a parliamentary law. Which means Parliament will enact a law and will include one community into SC list. So there will be one SC list. There will be one ST list at the central level. But who will notify this? President. Which means Parliament will pass a bill, and through that bill, one Métis group can be considered to be part of the ST community. But then the President will have to notify it by notifying an SC/ST Constitution Order of 1950. But can there be one ST group recognized in a state? Yes. Although you may not be recognized at the center, but you are recognized in that state. Yes. But the President will notify based on the consultations that you have with the governor of that state. So can Métis, or for that matter, can X be considered as SC in one state but not at the center? Yes. Can it be considered ST in one state but not at the center? Yes. But who will notify SC or ST in a state? President, after consultation with the governor. And this will be done on the basis of the law passed by the Parliament. Where is it mentioned? Article 341. Same goes for scheduled tribes as well. President will notify SC/ST order of 1950 based on the law passed by the Parliament. And that is why this question was asked in the examination. In Prelims 2024, it is the governor of the state who recognizes and declares any community of that state as scheduled tribe. It's not the governor, it's the President. In consultation with the governor, but it's the President. A community declared as a scheduled tribe in a state need not be so in another state. Yes. Which of the above statements given are correct? Is or are correct? 2 only. B is the right answer. Any questions as of now? There are some articles which you need to remember, especially those articles which have been in the news for the last 1.5 years. Those articles you have to remember. Socially and educationally backward classes. Now, what about OBCs? SC/ST, President, based on the law passed by the Parliament. Similarly, President may, with respect to a state or a union territory, if it's a state with consultation with the governor, specify that these socially and educationally backward classes in the central list are there for the state as well. That means this group will be treated as OBC in the state as well as at the center. You may know this more than and better than me. Maybe your group, maybe your caste is under OBC in a state, but not in the central OBC list, which is the case. Initially, the court said, listen to me carefully, who has the power to decide whether this group is an SC group or an ST group, recognized in that state, recognized at the center? Who has that power? That power is with the center. President, Parliament. But who has the power to categorize or to recognize OBCs in the state? Supreme Court said only the center.
Why? Because Supreme Court said, now that you have given constitutional status to National Commission for the Backward Classes, just like you have given constitutional status to National Commission for Scheduled Castes and Scheduled Tribes. So there will be SC and ST groups notified by the president at the central level as well, at the state level as well. So similarly, only the president will notify OBCs at the state level. Only the president will have the power to notify OBCs at the central level. This was the judgment given by the court. And this was the judgment which was heavily criticized as well, because it took away the power of the states to recognize OBCs. That is why Constitution was amended, 105th Constitutional Amendment Act. And 105th Constitutional Amendment Act said, no, the power is with both Parliament as well as states, which means the president as well as the state, which means the union as well as the state. Union will recognize OBCs at the central level, but states and union territories, you will have the power to declare your own socially and educationally backward classes of groups at the state level. So for OBCs, states have a role. For SCs and STs, states do not have a role. That is Article 342, capital A. Now let's look at Part 17 of the Constitution, that is related to official language. Shall we continue, or should we end here and come back again maybe next week to discuss the remaining provisions if you are feeling tired? Sagnik says continue, so I will continue. Sagnik is my favorite student. Okay, let's look at official language. Constitution says the official language of the Union shall be Hindi in Devanagari script, according to Article 343. But the same Constitution says English, which was previously the official language, will continue even after the commencement of the Constitution, but only for 15 years. After 15 years, English will disappear, and only Hindi, that too in Devanagari script, will be the lone only official language of the Union. But Constitution further says, if Parliament wants, it can enact a law, and through that law, it can provide for the continuance of English even beyond 15 years. And that's how Parliament has enacted a law, Official Languages Act 1963, which says both Hindi as well as English are the official languages of the Union. And there is no upper limit, there is no time limit for an indefinite period, unless and until Parliament decides to repeal that law or to amend that law. Both Hindi as well as English, they are the official languages of the Union. But Constitution further said, the President shall, at the expiry of 5 years from the commencement of the Constitution, and then after 10 years as well, which means first in 1955, then in 1960. What the President will do? President will set up a commission. What will President do? President will set up a commission. Commission on official languages. To do what? To recommend how we can progressively use Hindi, and which are these areas where we can stop our reliance on English. And then whatever report is prepared by this commission, this report has to be examined by a parliamentary committee. And that is how in 1955 a commission was set up, headed by B.J. Kher. And then this report of the commission was examined by the parliamentary committee, which was headed by Gobind Vallabh Pant, G.B. Pant. But then in 1960, this commission was not set up. Why? Because there was chaos on the official language, protests by the southern states, particularly the then state of Madras, Tamil Nadu. Long story short, we have Hindi as well as English as the two official languages of the Union. But you would also know by looking at and reading the provisions of the Constitution, there is no such thing as the national language. Hindi is not the national language of India. Clear? And then we see the glimpses of, headed by Fazal Ali, K.M. Kunzru, H.M. Panikkar, H.N. Kunzru, K.M. Panikkar. This commission recognized that yes, language can be the basis for reorganization. That we can reorganize states in the name of language, although previous commissions, for example, JVP committee or Dar commission, they had categorically rejected that Parliament should not reorganize states in the name of language because it may further lead to the balkanization of India. So one aspect of linguistic federalism that we see in India is because the states were created, reorganized in the name of language. At second, we see in Article 345, does Union insist on the state that you should have X language as your official language? Or does states have their own freedom to choose any language as the official language? States have the freedom. And states have the freedom to choose any language as their state language, even if that language is not mentioned under Schedule 8 of the Constitution. So freedom given to the states to choose any one or multiple languages as your state languages, even if those languages are not mentioned under Schedule 8 of the Constitution. That is the official language of a state. And then what will be the official language for communication between one state and the other? For example, Tamil Nadu has to communicate with Uttar Pradesh. Mr. Stalin has to communicate with Yogi ji. Yogi ji writes in Hindi, Stalin writes in Tamil. Although they may both understand, but they will assume that we have not understood each other. But be that as it may, which language should be used for states to communicate with each other? Either they can use the language which is used at the Union, which means Hindi and English, or they can use only Hindi. This is where various state governments, for example, UP, Rajasthan, Madhya Pradesh, they have decided that for now and from now onwards, whenever we have to communicate with each other, we will communicate only in Hindi. That's a provision in the Constitution. Similarly, what if there is a state, for example, Karnataka, and there is one language, Tulu, spoken by Aishwarya Rai or Shilpa Shetty, or for that matter, any language X, which is spoken by the people, but it is not recognized by the state. What can the speakers of this language do? They can demand the President of India that, dear President of India, look at us, we have a substantial population. We speak this language. We want your interference so that this language is recognized by our state. And on that demand, the President may direct to the state government that this language X be considered as the official language of that state as well. That is also a provision in the Constitution. So one is by center through force. The other is unilaterally by the states. They can choose any language as the state language. Not necessarily one language, they can choose multiple languages. And what will be the language used in the Supreme Court and in the High Courts? language used shall be English. That is why there have been various petitions also. If you look at some of the YouTube shorts where one lawyer is in a heated brawl with the judge that you should accept my Hindi petitions because Hindi is the spoken language by the majority of the people, but the judge is not relenting, the judge of the High Court, because the language for the High Courts, for the Supreme Court, shall be English. Similarly, special procedure for enactment of certain laws relating to language. I told you the official language of the Union shall be Hindi in Devanagari script. But English will be used for 15 years. After that, English will not be used. But if the Parliament may want, Parliament can enact a law, and through that law, it can say that even after 15 years, we can continue with English as the official language of the Union. And Constitution says under Article 349 that it has to be, such a bill has to be introduced in either of the houses of the Indian Parliament, that too with the previous sanction of the President. And the President will give sanction to this bill only after taking into account the recommendations of the Commission. Which Commission? Because after every 5 years, and then after the expiry of 10 years, a commission has to be set up on official language. If this commission has given, this commission has to be consulted by the President so that the President can give approval to that bill, which is passed, so that English can continue beyond a period of 15 years. That's Article 349. Article 350. Every person shall be entitled to submit a representation for the redress of any grievance to any officer or authority of the Union or a state in any of the languages used in the Union or in the state. For example, in Tamil Nadu, we have an IAS officer and he is the officer of the Union. So I have to give a representation of my grievance to this IAS officer. In which language? It can be Tamil, it can be Hindi as well, because Hindi is the official language of the Union. And this officer is of the Union. So I can give representation in any language which is spoken in that state or at the Union. That's Article 350. Article 350 capital A, which is again a product of the States Reorganization Act, which is again a product of the linguistic arrangement of states in India, where states were created in the name of language. Marathis in Tamil Nadu, these are linguistic minorities, because Constitution recognizes minorities on two grounds, either on the grounds of religion or on the grounds of language. Marathis in Tamil Nadu are linguistic minorities. That means minorities on the basis of their language. Would it be possible, because we need to also preserve their mother tongue, that the kids belonging to these linguistic minorities in Tamil Nadu should be taught in Marathi, at least till the primary stage of their education, at least till the 5th standard? Yes. What if Tamil Nadu does not abide by it? A directive can be issued by the center under Article 365. That Tamil Nadu, there are Marathis who are the linguistic minorities in your state. Your government or your local governments, because government schools can also be panchayats, panchayat schools, because education is under panchayats, or urban local bodies, there can be municipal schools. We are issuing you a directive that you have to teach these Marathi kids in their own language, Marathi, till the primary stage of education. And if you fail to abide by this directive, we can assume that there is a breakdown of constitutional machinery in your state. And then we will recommend to the President that, dear President, please impose Article 356 and dismiss Stalin and his government. Impose President's rule. That is the feature of Article 350 capital A. And then Article 350, Clause B, it talks about Special Officer for Linguistic Minorities. This constitutional entity will be appointed by the President. And what is the duty of the Special Officer for Linguistic Minorities? That there are some linguistic safeguards attached to these minorities, whether they are taught in their mother tongue till the primary stage of education, whether the government officers are accepting their grievances in their mother tongue, whether these constitutional safeguards are being followed or violated, that will be investigated by this Special Officer for Linguistic Minorities. And then the report of the special officer will have to be presented before the House of the Parliament and then sent to the governments of the states concerned. This fact becomes important for your exam. That the job of this special officer for linguistic minorities is not only to hear the grievances, but also to present a report to the government, which will then present it before the Parliament and then send it to the concerned state, which is violating these constitutional safeguards. And then Article 351, which is considered to be fossil in a sense that expiry date has come. It should no longer be relevant now. But whether it is relevant now or not relevant, we have to discuss it. If the union government is blatantly promoting Hindi, is that something unconstitutional? No. Why? Because Constitution imposes a duty on the union. Constitution does not impose duty on the states. Constitution imposes duty on the union. That union, you have a responsibility. That you have to promote the spread of Hindi language, so that Hindi can become the medium of expression for our composite culture. That is the responsibility on the union under Article 351 of the Constitution. Any questions as of now? Right to agitate. Yes, the citizens or the linguistic minorities, they have the right to agitate even for the protection or the promotion of their language. Or this right is not only for linguistic minorities, this right is for everybody, every citizen of India who has a distinct language, script or culture of its own, and you want to preserve that language or script. You have the fundamental right to do that, and you can even agitate for the protection or the promotion of your language. That's under Article 29, Clause 2, 29 of the Constitution. Okay. So let's take a break now. We will come back at 12:15 a.m. tomorrow morning. I'll see you in a day. And then we will discuss emergency provisions of the Constitution. Then it should not take more than an hour. It will take roughly 1 hour or 90 minutes. And we will wrap up the session. See you on the other side of the break at 12:15 a.m. Welcome back. Let's discuss part 18 of the Constitution dealing with emergency provisions. The first is the national emergency under Article 352 of the Constitution. Constitution says if the president is satisfied, but we know in a parliamentary democracy, it is not the personal satisfaction of the president, it is the satisfaction of the government or the cabinet headed by the Prime Minister. If the president is satisfied that a grave emergency exists where the security of the India, the nation, or any part of the territory of India is under threat, and this can be under threat because of war or external aggression or armed rebellion. Now, this term, armed rebellion, was not originally part of the Constitution. It was inserted in place of internal disturbance. And this term, internal disturbance, was misused because it's vague. And that is how emergency was imposed in 1975. And that is how, after the emergency, when the government was formed, the 44th Constitutional Amendment Act, 1978, provided a lot of safeguards to prevent the misuse of Article 352. And that is how, instead of internal disturbance, the term used was armed rebellion. Now it becomes clear. If the president is satisfied because of the war or external aggression or armed rebellion, that the security of the nation is under threat or any part of the country is under threat, then what president can do? President can proclaim national emergency. This national emergency will continue for 30 days. But within 30 days, if both the Lok Sabha as well as the Rajya Sabha approve this national emergency. And how will both houses of the parliament approve national emergency? By passing a resolution. But this resolution has to be passed by special majority. Then this national emergency can continue for 6 months. Can it be continued further, extended further? Yes, another 6 months, provided both houses of the parliament again pass a resolution by special majority approving the continuance of the national emergency. Can it be extended further for another 6 months, provided both houses of the parliament approve? Is there any upper limit? No. Why? Because we don't know for how long this grave emergency will exist, which will threaten the sovereignty, integrity of the nation. That is why there is no upper limit, but each time Parliament needs to approve it for 6 months. And this is what we call periodic parliamentary control. Parliament exercising control after every period of 6 months to prevent the misuse, the overuse, the abuse, the hyperuse of Article 352. And can this national emergency be revoked? It can be revoked at any time by the president. But president cannot revoke national emergency on her own. She again needs the approval of the cabinet. And that too approval is written advice of cabinet. That means ministers of the cabinet rank. And even this term cabinet was inserted for the first time in the Constitution by the 44th Constitutional Amendment Act, 1978. Because previously the emergency could have been imposed on the oral advice of the Prime Minister, not the written advice of the cabinet. Now, the written advice of the cabinet is necessary for the president to proclaim national emergency. That is Article 352 of the Constitution. But what is the impact of the proclamation of emergency? I've told you that during national emergency, it is as if Parliament enjoys concurrent power of legislation, which means of all the matters that are mentioned in the state list, although during national emergency, state legislatures are not dissolved, state executive also is not dissolved. But during national emergency, the state executive and state legislature, they come under the grip, under the control of the union, which means Parliament can make a law on any item mentioned in the state list. Union government can issue directives to state government on any matter. And if the state executive does not abide by those directives, we can assume that there is breakdown of constitutional machinery, dismiss the state government. And during national emergency, there is an impact on fundamental rights. Fundamental rights in the sense, if emergency is imposed on the grounds of war or external aggression, then Article 19 is automatically suspended. But if it is imposed on the grounds of armed rebellion, then Article 19 is not automatically suspended. Or should we say fundamental rights under Article 19 are not suspended. Their enforcement is suspended. That means you can't approach the court in case your Article 19 is violated. That is the national emergency under Article 352. What about other fundamental rights, sir? Park your doubts. We will discuss that in Article 359. Then Article 355, it imposes a duty on the union. And please, from Lakshmikant, revise the entire chapter of emergency provisions, Article 352, 356, 360. That will be important for your exam. But Article 355 imposes a duty on the union, that dear union, you have a duty. You have to protect every state from external aggression as well as internal disturbance. And at the same time, you have to ensure that governance is carried out in every state according to the constitution. That is why in Manipur, Article 355 was imposed, where the security of Manipur was under the control of the center. And then Article 356 can be imposed. Article 356 says, if the president is satisfied, what will satisfy the president? Again, it is not the personal satisfaction of the president. It is the satisfaction of the Council of Ministers, the cabinet headed by the Prime Minister. If the president is satisfied on the basis of the report of the governor, or even otherwise, and what would be mentioned in the report of the governor? That there is breakdown of constitutional machinery in the state. Now, what is this breakdown of constitutional machinery is not defined in the constitution. But what is the fit case of president's rule? That has been decided by the Supreme Court in the S.R. Bommai v. Union of India 1994. Because here the Supreme Court said that federalism is part of the basic structure of the Constitution. And if you're misusing Article 356, you are violating federalism, which is part of the basic structure, which we will not allow. So we will tell you what are the fit cases, what are the unfit cases of president's rule. The mere allegation of corruption against a minister does not mean that there is breakdown of constitutional machinery. The very fact that the government has failed to implement its election manifesto after winning the election is not a ground for president's rule. Just because the political party in power in the state has lost the Lok Sabha election, that is not the fit case of president's rule. If secularism is violated, then it is a fit case of president's rule, because secularism is also part of the basic structure of the constitution. Long story short, if there is a breakdown of constitutional machinery, not the breakdown of law and order, because Supreme Court clarified that there is a difference between breakdown of law and order and the breakdown of constitutional machinery. But if the president is satisfied on the basis of the report of the governor, or even otherwise, that means the report of the governor is not necessary. Even without the report of the governor, if the president is satisfied that there is a breakdown of constitutional machinery in a state, the president can proclaim president's rule. And because of that, immediate casualty is Council of Ministers headed by the Chief Minister, dismissed. Now, who will act as the executive for that state? The president. What will happen to the legislature, the legislative assembly? Will that be dissolved? No, not immediately. It will be kept under suspended animation. This legislature can be revived. For example, in Manipur, Legislative Assembly has not been dissolved. It is under suspended animation. That means tomorrow, if the BJP would be in a position to choose a chief minister, to choose the leader of that government, maybe they will be able to form the government again, and that Legislative Assembly will be revived, because right now it is not dissolved. It's kept under suspended animation. That is why there was a question asked once in your prelims examination. Which of the following are not necessarily the consequence of president's rule? Dissolution of the Legislative Assembly, not necessary. Dissolution of the local bodies. Local bodies have got nothing to do with president's rule. Even with president's rule, local bodies survive and continue. But the immediate casualty is, yes, the chief minister and the council of ministers are dismissed. And the president in her proclamation will say that the executive powers will now will be with the president. And legislature will be with the parliament or an authority under parliament. And in fact, one thing which I missed here, in case of national emergency, the term of Lok Sabha and Legislative Assembly may be extended as well by 1 year at a time. Because when we are in a state of emergency, maybe because of war, maybe because of external aggression, maybe because of armed rebellion, when it is not possible for the elections to take place, during that period, the Lok Sabha, whose term may get over in 5 years, the term of the Lok Sabha is extended by 1 year, then another 1 year, another 1 year. But if national emergency is revoked, then elections have to take place. Similarly, when there is president's rule, what happens during president's rule? Fundamental rights are unaffected. Fundamental rights are affected during national emergency, but fundamental rights remain unaffected during president's rule. It's only that the union will take over the functioning of that state. Even the budget will be passed by the parliament, because parliament will assume the role of the legislature of that state. For example, for Manipur, the budget was presented by the union finance minister. That is president's rule. But president's rule will have a validity. What is the validity of the president's rule? President's rule will continue for 2 months. But within 2 months, both Lok Sabha as well as the Rajya Sabha will have to approve separately. What president's rule? How will it approve? By passing a resolution. And this resolution has to be passed by simple majority. And if both houses of the parliament approve president's rule by simple majority, president's rule continues for 6 months. Then it can be extended for another 6 months. That means maximum for 1 year. Can president's rule be extended beyond 1 year? Yes, for a maximum period of 2 more years. That means what is the maximum constitutional validity of president's rule? 3 years. But beyond 1 year, you can extend the duration of the president's rule if two conditions are met, if two conditions are satisfied. Which are these two conditions? Number one, either national emergency is imposed on the entire country or in that state or any part of that state. Because it's not necessary that national emergency be imposed in the entire country. It can be imposed in any state. It can be imposed in any part of that state as well. And Election Commission of India will have to certify that it is not possible to hold elections. But sir, in case of Punjab, president's rule was extended for 5 years, not 3 years. Because for Punjab, constitution was amended that this 3-year term would mean 4 years. Then 3-year term would mean 5 years. This is president's rule. And then we have Article 357. Whenever proclamation under Article 356 is issued, who will make laws for that state? Parliament. Who will be the executive authority of that state? President. That is under Article 357 of the Constitution. But President cannot take over the powers of the concerned High Court. This is an important matter, important fact, can be important for your examination. Suspension of provisions of Article 19 during emergencies. As I told you, when emergency is imposed on the grounds of war or external aggression, Article 19 is automatically suspended. If it is imposed on the grounds of armed rebellion, then Article 19 is not automatically suspended. Even then, if we want Article 19 to be suspended, then you have to issue an order under Article 359. That the President may issue an order under Article 359 and suspend all fundamental rights except Article 20 and Article 21. During emergency, Articles 20 and 21 are not suspended. Their enforcement is not suspended, whereas other fundamental rights could be suspended. Sir, I have a question. What about Article 32? Would it be suspended? Because you said only Article 20 and 21 are not suspended. I told you articles are not suspended. Their enforcement is suspended. That means Article 32 in relation to Article 14, 15, 16, 17, 19, 23, 25 is suspended. But Article 32 in relation to Article 20 and 21 is not suspended. That means if violation of Article 20 and 21 takes place, you can approach the Supreme Court under Article 32. And then there is financial emergency. If the President is satisfied that a situation has arisen whereby the financial stability or the credit of India is threatened, then the President can proclaim financial emergency. Once this financial emergency is imposed, it continues for 60 days. But within 60 days, and this is also for President's rule, have I mentioned it here? Yes, 2 months, 60 days. Within 60 days, both Lok Sabha as well as Rajya Sabha, they will have to approve this financial emergency by passing a resolution by simple majority. And if it is approved, financial emergency continues unless revoked by the President. And the President, you would know, can revoke financial emergency only on the advice of the Cabinet. This is not the discretion of the President. Has national emergency been imposed Any time in India? Yes. How many times? 3 times. 1962, 1971, and 1975. Has president's rule been imposed in India? More than 100 times. The highest number of times in Manipur, UP, for a longest period in Jammu and Kashmir. Has financial emergency been imposed any time in India? Never. But what may happen during financial emergency? Money bills can be asked to be reserved for the consideration of the president. Directives can be sent by the union to the state that you observe the canons of financial propriety. That means observe austerity measures, save money as much as possible. The salaries of government employees may be reduced, including constitutional functionaries. Normally, the salary of the judges of the Supreme Court, the Chief Election Commissioner, they cannot be varied to their disadvantage once they're appointed. But their salaries can be varied to their disadvantage, can be reduced only during financial emergency, because we have to save money, because there is a grave situation which has arisen whereby the financial stability or the credit of the system, credit of the nation is under threat or threatened. That is emergency. So this is provision related to emergency under Part 18 of the Constitution. Now let's look at Part 19. It talks about miscellaneous things. Remember, EMAS, emergency provisions, then miscellaneous, then amendment to the Constitution, then short title, so on and so forth. Protection of president and the governor. For example, this talks about immunity. Can a criminal case be filed against the president or the governor while they are in office? No. Can any action be taken against the president or the governor while they are discharging their official duties? No. Where is it mentioned? This is mentioned under Article 361 of the Constitution. So Article 361 gives immunity to the president and the governor. Similarly, protection of publication of proceedings of parliament and state legislatures. Now listen to me carefully. Something has been said in the parliament which may be, let's say, contempt of court, which may be inciting people to offense. That's part of the proceedings of the parliament. But inside the parliament, legislators have absolute freedom of speech and expression. They can say whatever they want to say. And for whatever they say, they will not be held accountable in any court of law. But they will not be held accountable. But what if the Hindu is publishing those proceedings? What if the Indian Express is publishing those statements? Will the newspapers or the publishers of the newspapers, editors, will be held accountable? No person shall be held accountable. If what these newspapers are publishing is the true report of any proceeding of the parliament or any proceeding of any committee of the parliament, but only if the publication has published it without malice, without ulterior motives, if it is proven that they have published the proceedings of the parliament with an intention to cause riot, with an intention to polarize the society or cause enmity amongst different sections of the society, then they will be held accountable. But sir, I have a question. What? Sir, what about secret sittings of the parliament or the state legislature? If it's a secret sitting, then no one can publish the proceedings of the secret sitting of the parliament, because that is the privilege of the parliament. The privilege of the parliament to ensure, to organize a secret sitting where it may exclude strangers. Strangers includes you and me, the non-members. That's Article 361, capital A. Now listen to me carefully. Article 361, capital B. inserted by the 91st Constitutional Amendment Act 2003. We know there is anti-defection law. Which was passed by the Parliament in 1985 because of the 52nd Constitutional Amendment Act, the 10th schedule of the Constitution, under which if I am a member of a house belonging to a political party, if I have defected, I will be disqualified. Even if I was disqualified, I was still made a minister. Even if I was disqualified, I was appointed to a post, let's say a statutory body. Let's say a constitutional body such as National Commission for the Backward Classes or National Commission for Scheduled Castes, Scheduled Tribes, or statutory body National Commission for Women. Then you are basically legalizing plunder and loot. You are basically legalizing and giving boost to this defection. Thanks to Mr. Vajpayee, Constitution was amended to say that a defector cannot be appointed to any remunerative political post till the time you are disqualified. It's another matter if after you are disqualified, then you contest election again, because once you are disqualified under anti-defection law, can you contest elections again? Yes. Can you win? Yes. And then once you have won, you are a member of the house. You can be appointed. You can be appointed as a minister. But while you are under the period of disqualification, when you have not been re-elected, during that period, you cannot be appointed to any remunerative political post. Now, what is that remunerative political post? A post for which the money or the salary is charged from public revenue. Any post for which the salary, the money, the emolument is taken from the public funds, from the public revenue, that is a remunerative political post. A defector, unless and until you are re-elected, you cannot be appointed to any remunerative political post. And Article 365, where I told you that if the union government issues directive to the state that you construct and maintain railways, construct and maintain national highways or national waterways, that you maintain means of communication, for example, posts, telegraph. And what if the state fails to comply with that directive, fails to abide by that directive? It can be viewed that there is breakdown of constitutional machinery. President's rule can be imposed. Whenever a state has failed to comply with or give effect to any directions given in the exercise of the executive power of the union, it shall be lawful for the president to hold that a situation has arisen in which the government of the state cannot be carried according to the provisions of the Constitution, which means there is breakdown of constitutional machinery. And whenever there is a breakdown of constitutional machinery, what happens? The president can proclaim president's rule. Article 367 talks about interpretation. Just keep this in mind. Interpretation in the sense, for example, in Article 370, which was a special status, although a temporary status for Jammu and Kashmir, it was mentioned that President can, through public notification, notify or declare that Article 370 would cease to exist or will exist with these many modifications. But this notification cannot be issued by the President without the recommendation of the Constituent Assembly of Jammu and Kashmir. But there is no Constituent Assembly of Jammu and Kashmir because it got abolished in 1956 when it gave constitution to Jammu and Kashmir. But how do we interpret this Constituent Assembly? Article 367 was used to say that interpretation of Constituent Assembly of Jammu and Kashmir means Legislative Assembly of Jammu and Kashmir. So interpretation of the Constitution is provided under Article 367. Sir, can you give one more example so that it becomes clear? I will give one more example. Interpretation, we say, includes General Clauses Act of, I think, 1897, if I'm correct. What is this General Clauses Act? You may have a question. What is the question? Sir, entire Constitution of India, sorry to say, but appears as if it is sexist, because it only uses the pronoun he. If the president is satisfied, he can do this. If the governor is satisfied, he can do this. The prime minister the ministers are appointed by the president on the recommendations of the prime minister, and then on his recommendation, other ministers are appointed. Does that mean he is different from she? His is different from her? Or does it include both? How do we interpret this term he and his? Because law has to be clear. Law has to be clear in the sense, if you have watched that beautiful series on Netflix called Suits, where Louis Litt is asking questions to Mike Ross and the other gentleman, and Mike Ross gives an answer, and Louis Litt says, no, this is not the right answer because your answer has to be precise, because law is the precise science or language. And then he asks another question, how many chief justices of the Supreme Court are from Harvard? One person says 5, Mike Ross says 6, Louis Litt says, no, it's 5. Then he cites one example of another judge, but he says, but this judge did not graduate from Harvard, he was the graduate from Columbia University. But Mike Ross says, but law has to be precise. You did not say how many graduated from Harvard University. You said how many were from Harvard University. And this person was from Harvard University, although he did law from Columbia. Because law has to be precise. Because it can be misused later. Interpretation would be a problem. That is why we say that for interpretation, we have to go through General Clauses Act of 1897. And General Clauses Act of 1897 says, whenever he is used, that also means she. Whenever his is used, that also means her. It also talks about computation of time. Simple things. For example, if you have to file your application by this time, and by that time the office is locked, you can also file the application tomorrow. So interpretation of things that are mentioned in the Constitution, for that we have to look at the General Clauses Act of 1897. But this has to be mentioned somewhere. Why do we use and how can we use General Clauses Act for interpretation? Because that is provided under Article 367 of the Constitution. Clear? Okay? Great. Now, Part 20 of the Constitution, Amendment of the Constitution. And what is this amendment? Article 368. Look at the question. Asked last year in Prelims 2024. As per Article 368 of the Constitution of India, the Parliament may amend any provision of the Constitution by way of addition, variation, repeal. What is the answer? D, 1, 2, 3. Sir, how do you know? Look at Article 368. Originally, it was said that the title of Article 368 is Procedure for Amendment. And in Golaknath case, this was the matter of dispute. Because in Golaknath case, Supreme Court said Parliament does not have the power to amend the Constitution. Parliament does not have the power mentioned in the Constitution to amend the Constitution. Because Article 368 only talks about procedure for amendment. It does not talk about power of the parliament to amend the constitution. This is where constitution was amended when Indira Gandhi was the prime minister, and parliament said and amended Article 368 to rewrite the title of Article 368. And now this rewritten article title says power of the parliament to amend the constitution and the procedure therefore. This was the 24th Constitutional Amendment Act 1971. And Article 368 says, notwithstanding anything in the Constitution, Parliament may, in the exercise of its constituent power, because Parliament has two types of power, constituent power and ordinary lawmaking power. That means it has a power to make a law on any item mentioned in the union list, any item mentioned in the concurrent list. But it also has a constituent power. That means we can assume that this parliament is like the Constituent Assembly. Constituent Assembly is to draft the constitution. Similarly, parliament has the power to amend the constitution by way of addition, variation, repeal. Same statement, verbatim. Addition, variation, repeal. Prelims 2024. That's the significance of the Bare Act. Right? Very good. But for that, we need a constitutional amendment bill. What is a bill? Bill is a proposal. Proposal to add a fundamental right. Proposal to add a fundamental duty. Proposal to add a part. Proposal to remove a part. Proposal to add a clause. Proposal to modify. Proposal to repeal a fundamental right. Proposal to repeal a part. Proposal to add something. Proposal to modify something. This is a bill. This constitutional amendment bill can be introduced in either house. That means can be introduced in either Lok Sabha or Rajya Sabha. Can be introduced by a minister or a private member. That means can a private member move a constitutional amendment bill? Yes. And this constitutional amendment bill does not require prior approval or consent or permission of the President of India. This we have to clarify, because for a money bill, prior approval is necessary. For a financial bill, prior approval is necessary. For a bill under Article 3, prior approval is necessary. So long story short, a constitutional amendment bill can be introduced in either Lok Sabha or Rajya Sabha, although it has to be passed by both. But where it is to be introduced in the first place, for the first time, it can be introduced in either of the two houses by a minister or a private member. It does not need prior approval of the president, and it needs to be passed by Lok Sabha and Rajya Sabha separately. What if one house passes and the other house does not? No room for a joint sitting. It has to be passed by both houses of the Indian Parliament separately, that too by special majority. Sir, which type of special majority? Flavor 2, vanilla. Not less than 2/3 of the members present and voting, and by the majority of the total membership of the House. Then constitutional amendment bill is passed. And then it is sent to the President. What are the options available with the President? According to 24th Constitutional Amendment Act 1971, the President shall give his assent to a constitutional amendment bill. This is where interpretation becomes important. If the Constitution says that the president shall give assent to a constitutional amendment bill, what if a constitutional amendment bill is passed today? It is sent to President Srimati Draupadi Murmu. She says, I'm not going to sign it. Why? You can't do that. Why? I can do that because Constitution says president shall give his assent. It doesn't apply to me. It applies only to a president who is a male. I'm a female. It doesn't apply to me. Then we have to tell the president, Madam, look at the General Clauses Act of 1897. It talks about interpretation. And there it says categorically that he and she means the same. His and her means the same. But if this constitutional amendment bill tries to amend some federal features, and which are these federal features? If you change the manner and method of president's election, for example, tomorrow you have to include the MLAs of Jammu and Kashmir Union Territory as part of the Electoral College. For example, you have to remove states from Electoral College. For example, you change proportional representation system into first past the post. You need ratification by not less than half of the states. And how will states ratify? They will pass a resolution. But sir, when they will pass a resolution, their resolution should be passed by what type of majority? Simple majority. If you change any item in Schedule 7, for example, you shifted education from state list to concurrent list because you're modifying Schedule 7, any of the list in the 7th schedule, you need ratification by not less than half of the states. If you change Chapter 4 of Part 5, Chapter 5 of Part 6, what does that mean? That means chapters related to Supreme Court and High Court. For example, when NJAC was passed by both houses of the parliament, it was sent to all the state legislatures. And when not less than half of the state legislatures passed a resolution by simple majority approving NJAC, then NJAC bill was sent to president for assent. If you change the representation of the states in parliament, which means representation of states in Rajya Sabha, you need ratification by not less than half of the states. If you change the extent of executive power of the union or the states, you need ratification by not less than half of the states. Or if you change provisions of Article 368 itself, if you want to modify Article 368 itself, for that you need ratification by not less than half of the states. And when this bill is sent to president for assent, president has no other option but to give assent. That's according to 24th Constitutional Amendment Act 1971. Now we are almost coming to the close. Part 21. Total parts are 25, but number 22. So now it is 21. After that, 22. Then sayonara, good night. Temporary, transitional, and special provisions. Temporary provision was Article 370. But is Article 370 now deleted? Anyone? Can the president use pocket veto for constitutional amendment bills? No. Is Article 370 now deleted? No. Then what Article 370? I don't have to explain Article 370 now, but very briefly. Article 370 would say originally that only Article 1 and Article 370 shall apply to Jammu and Kashmir, which means other articles are not applicable. In Union list, there is defense, external affairs, communication. Parliament is empowered to make a law only on these three items in the union list. All other items are under state of Jammu and Kashmir. Which means if there are 97 items in union list on which for all other states Parliament has the power to legislate on these 97 items, but with respect to J&K it was only on 3 items, not on the remaining 94. This was Article 370. Article 370 further said, apart from Article 1 and 370, can other provisions of Indian Constitution apply to Jammu and Kashmir? Yes. For that, President will issue a notification, but that notification can be issued only with the concurrence of the state government. Which means the government can say, can we apply Article 14, 15, 16, 19, 20 to Jammu and Kashmir? If the state government says yes, you can apply. Can we apply other items in union list to Jammu and Kashmir? Yes, for that President will have to issue a notification, that too with the concurrence of the state government. And on August 5, 2019, when the special status for Jammu and Kashmir was withdrawn, revoked, 94 out of these 97 items were made applicable to Jammu and Kashmir, were already applicable to Jammu and Kashmir. Fundamental Rights Chapter was applicable. Supreme Court was applicable. Election Commission was applicable. CAG was applicable. UPSC was applicable. Emergency provisions were applicable. President's rule was applicable. Major provisions of the Constitution were made applicable. Why? Because President had previously issued notification with the concurrence of the state government. Then what was done on August 5 and August 6? On August 5, President issued a notification and said, now entire Indian Constitution is applicable to Jammu and Kashmir. So previously by bits and pieces, through piecemeal, one by one, Indian Constitution was made applicable to Jammu and Kashmir. Now in one go, entire Indian Constitution was made applicable to Jammu and Kashmir. But for that, concurrence of the state government was required. State government gave the concurrence because who was the state government? Governor, because the state was under President's rule. And on August 6, 2019, President issued another notification and said, now entire Article 370 is gone. The only article which remains is the skeleton, which says all the provisions of Indian Constitution as applicable from time to time without any modification, without any exception, notwithstanding any article of the Constitution, anything else mentioned in the Constitution, any judgment given by the Constitution will apply to J&K. Because prior to that, Article 370 had clauses, clause A, B, C, D. Now those clauses are gone, only one title remains, only one paragraph remains, that's Article 370. So Article 370 is still part of the Constitution, but it is inoperative. It is under Part 21 of the Constitution dealing with temporary provision. So temporary provision is Article 370. Special provision is, for example, Article 371. You remember those states where there is a special status. There are some states which are given special status by the Constitution. And this is what tells us about the asymmetrical nature of our federalism. Do we have a federal structure? Yes. Is it a symmetric federal structure where all the states are treated equally? No. There are some states which are treated differently. As George Orwell would write in Animal Farm, all animals are equal, but some animals are more equal than others. All states are equal, but some states have special powers. For example, special power for special status for Maharashtra and Gujarat. What is that special status? There has to be separate governance board, development board in Maharashtra for Vidarbha, Marathwada and the rest of Maharashtra. In Gujarat for Kutch, Saurashtra and rest of Gujarat. Similarly, special provision for Nagaland. Nagaland has a special provision. Can the land in Nagaland be sold to non-Nagas? No.
because that is with the concurrence of the state legislative assembly. Can a parliamentary law apply to Nagas if it affects their customs, rituals? No. Unless and until the state legislature of Nagaland decides, okay, we will accept this law. So that's a special provision for Nagaland. And there the governor of Nagaland has a special responsibility to ensure law and order, because there was insurgency in Nagaland and there is insurgency even today. So special provision for Nagaland. Special provision with respect to the state of Assam. Some committee of legislators are to be constituted. Leave that. Similar provisions for Manipur as well. Leave that. Special provision with respect to the state of Andhra Pradesh and Telangana. Just keep in mind, we have Maharashtra, we have Gujarat, we have Nagaland, we have Manipur, we have Andhra Pradesh and Telangana. We have special provision for Andhra Pradesh that there has to be the establishment of a central university in Andhra Pradesh. Similarly, special provision with respect to the state of Sikkim. Sikkim was admitted to Union of India in 1974, first as an associate state, then as a full-fledged state. But Constitution says, although Constitution does not provide for a number of MLAs in a legislative assembly, but it prescribes a range that minimum we can have 60, maximum we can go up to 500 MLAs. But for Sikkim, the special provision is it can have 30 MLAs. 371G, special provision for Mizoram. Special provision for Arunachal Pradesh. Special provision for Goa. Similarly, for Goa, it can have 40 MLAs. Special provision for Karnataka. This is the last one which got added because of, I think it was 98 Constitutional Amendment Act 2011, where some special provision was provided to the 6 backward districts of Hyderabad, Karnataka region. And right now we don't call it Hyderabad, Karnataka region, we call it Kalyan, Karnataka. Raichur, Bellary, Bidar, Gulbarga, so on and so forth. 372. Continuance in force of existing laws and their adaptation. Article 395, which we will discuss, has repealed some laws, which we will discuss. Which are those laws which have been repealed? Those laws which have been repealed, forget about them. What about the remaining laws which have not been repealed? Can these laws continue within the territory of India? Yes. Unless and until those laws are repealed by the parliament or respective state legislatures, if that is the case. So prior to the commencement of the Constitution, there is something called Article 13, Clause 1. All laws in force prior to the commencement of the Constitution, if those laws are in agreement with fundamental rights, they will continue. Article 372 makes it clear that there are some laws which have been repealed by Article 395. Apart from that, what about other laws? They will continue unless and until they are repealed by the legislatures. That is Article 372. And now comes the last part, Part 22. What is the short title? Article 393 says the Constitution may be called the Constitution of India. Look at the title. If you can zoom onto this. Constitution of India, Constitution of India. What is the short title of this Constitution? This Constitution may be called the Constitution of India. Commencement of the Constitution. As I told you that there are some provisions of the Constitution which entered into force on 26 November 1949 itself, while the remaining provisions got enforced on 26 January 1950. Which are those articles which entered into force at once? This Article 394. Then Article 5, 6, 7, 8, 9.
This is related to citizenship. Article 60 related to the president. Article 324 related to the Election Commission of India. All these provisions shall come into force at once, and the remaining provisions of the Constitution shall come into force on the 26th January 1950, which day is referred to in this Constitution as the commencement of the Constitution. So if there is a question asked, according to the Constitution, what is the date of the commencement of the Constitution? That is 26th January 1950, celebrated each day as the Republic Day. What about 26th November 1949? Since 2015, we celebrate it as the Constitution Day. But this Constitution Day is not mentioned in the Constitution. Okay? 394 capital A. Constitution is there in English language. But there is a Hindi translation of the Constitution as well. For example, India, that is Bharat, shall be a union of states. The Hindi version starts with Bharat Atharth India. So first name is Bharat and then India. Can we treat that as well as the authoritative text of the Constitution? Will that have the same sanctity as that of the English version of the Constitution? Yes, according to Article 394 capital A. The authoritative text in the Hindi language. And who will publish it? The President. The last article, Article 395, repeals. Indian Independence Act has been repealed, 1947. The Government of India Act 1935 has been repealed. Although the major source of the Constitution of India is the Government of India Act 1935, but that has been repealed according to Article 395, because Part 22 of the Constitution talks about the short title, talks about the commencement, talks about the authoritative text in Hindi, and talks about repeals. And the last article in the Constitution is Article 395. Although there are 25 parts in the Constitution, but they are numbered till 22. Because there is Part 4 capital A, Part 9 capital A, Part 9 capital B, right? Part 14 capital A. Similarly, there are more than 450 articles in the Constitution, but they are numbered till 395 because there is 51 capital A, there is 243 A, B, C, D, O. So numbering is till 395, but overall we have more than 450 articles. And that, thankfully, hopefully, comprehensively covers the BEAR Act, the last and the final part of this series, the BEAR Act, where we have covered in Part 1, Part 2, Part 3, the entire Constitution, which I think will be extremely helpful for you in the prelims examination. It's not going to help you in the mains, but it is surely going to help you in the prelims examination. There are 153 students right now who are watching till midnight. Kudos to you. May all 153 of you qualify in your first attempt. And don't leave this session without pressing the like button. And once the live stream is over, please drop in your comment as well, whether this series has been of some help to you. So that after the stream ends, I will go through the comment section and I should see 153 comments. Good night. All the best. May all your legitimate dreams come true. I will see you again with Stage 4 of the Conquer Prelims, where we will discuss current affairs from the period June till April 2025. Bye-bye. Good night.